August. 30th May.
That's
30th May.
803.
Yeah.
13.
no.
अच्छा, इसका डेट दिखाया नहीं?
But my lords, in 803, I beg to appear before on behalf of the petitioner. The pleadings are now complete and the respondent has entered appearance, my lords. Any short date, my lords, because the NCDRC is proceeding with the matter.
Keep it in July.
Grateful, my lords.
This is for
15th May.
earlier because only
15th.
1 year sentence is there, is already inside for more than one.
Yes, call on the list.
Red
My
light.
lords, the trial is going to be, I'm so sorry, my lords, the trial is going to be concluded in NCDRC on 30th of May, my lords. Could it be please before that, my lords? Before 30th of May, my lord. Any returnable date as per lordship's convenience.
There is an apprehension.
My lords,
You have said apprehension.
my lords, I was at a party before them, my lords.
Let it conclude. If there is some illegality, we can look into it.
Obliged.
Yes.
Item 1, my lords, I appear for respondent number 224. I apologize, my lords, I filed my...
Right now, and we'll listen this matter. Please, will not permit you to.
No, my lords, I am passing it on.
Please.
Please, my lords.
Where is the land counsel for the state? What is the stage of trial, Mr. Khan?
Your Lordships, all the witnesses have been examined. Your
All?
Lordship. Yes, Your Lordship.
All?
9 witnesses, Your Lordships.
9 have been examined. How many remain?
Your Lordship, there are total 9 witnesses. I have got instruction that,
No, your counter says 9 PWs have been examined.
yes, Your Lordships.
So how many remain?
Your Lordships, it's still the 9th.
None, my lords, there are only
None.
9 witnesses.
What is the use of cancelling bail?
My lords, but still the issue is this, my lord, that all of them are out. They have influenced the trial.
Can't help it. See, the entire trial is over.
My
Keep
lord,
up with you.
yes,
You know that.
yes, please, my lords. But
Why we issued notice, but if all witnesses have now been examined
There is-
on a bail cancellation plea, can we direct that the trial should recommence from an earlier stage?
no, my lords. But
Can't do
they
What purpose will be served if we cancel the bail? Tell us.
my lords, it'll go. A message will go back because they're influential people within the community, my lords, who have.
Let the judge.
Since it is
But-
represented before us that
But my lord, lords,
recording of
precisely why
evidence of
because
all the
look,
prosecution
the state has
witnesses is
failed.
over. Come on. No purpose would be served in examining the claim of the petitioner on merits.
My lords, at least a direction to the state that they should have at least filed the appeal. I mean, we have been running pillar to post. I have
No,
2
no.
more.
See, if the trial is over, and this contains how he was killed in public. Let us see what happens.
My lords, and that is.
Yes.
Item number 2, the complainant, your lordship.
May I please?
Yes. Who is for the state?
I am appearing.
Charge sheet is filed on 18th April 25.
No charges.
No charges.
No, sir.
Why should this condition continue?
I don't.
You tell us.
Because you
Why
are
should this
8
condition
cases,
continue?
8 cases has been pending against.
8 cases
against-
pending.
There is no civil
This is a
dispute at all.
murder case,
No, your lordship.
323.
Your
And because of the
Since-
delay in commencement
Since
of
that order, your lordship, there is peaceful coexistence in the locality. Beside me, the other complainant there in locality is the habitual offender.
counsel, what about his right to shelter? All antecedents are 323.
And what's about my life and personal liberty, your lordship?
If you-
Any threat, I am protected by. I have filed my counter affidavit, your lordship, wherein the order of 4 September.
Lords also.
Yes.
My lords, also to
As
be
far-
fair,
as-
my lords.
As far as our livelihood is
Any issue-
concerned, he is
it's a-
earning lakhs of
it's a-
rupees.
It's a.
We could have understood that this particular
I'm saying
condition.
something more, my lords.
Ah,
The charges in a counter case on the other side is far more grave. It is.
on his FIR.
Yeah, because it is.
Where have you stated that?
I am not stated it.
You have
See,
stated in the counter
just-
affidavit as if the learned judge is absolutely correct.
my lords,
This SLP should be dismissed at the threshold
No, as an officer of the court,
Then why do you say
I-
something in the
this-
counter?
counter comes, my lords, to, later on, my lords
Tell us
drafted.
on his FIR, what are the charges?
Yeah, my lord, if my lord will read the entire FIR and the counter blast, it is the, how it started. Please see the
Where do we find it?
FIR, my lords. The counter FIR. How it started, my lords. Because the injuries are also graver on the other side.
Head injury.
Head injury is on the other. So the question, my lords, I'll just. Cross FIR, my lords, on page 28.
28.
Sorry, 29 it starts, my lords. 28 is the, 29 is the, yeah, clear FIR, my lords. 28 it starts, which is, the clearer version is on page 29. 30 it starts. This is your cross FIR. So this is his cross FIR.
30.
Please, my lords.
A small, may I say this,
As an
small submission, your lordship.
officer, sometimes we are not part of the
Please wait.
affidavit.
Grateful, my lords.
Next.
I filed the trial court record. Even if High Court had directed to proceed with the trial and complete it within 1 year, 12 dates have been fixed for prosecution evidence. None of the witness has presented itself.
This is first time?
A lordship may kindly have additional
Notice issue.
document.
Notice issue नहीं हुआ है. Notice.
Much obliged.
Notice. He asked for time to file additional documents.
Please, my lordship. In item 4, I am for the complainant, my lordship, the de facto complainant.
About settlement.
She is also there through VC, my lordship. We have received a proposal, my lordship. They are offering 6 plots and total amount.
Be the proposal, either yes,
No, my lordship.
either no. If there is no settlement,
My-
we'll decide on merit.
We are ready for the settlement, but not the plots, my lordship. I am a single mother, so I need the money for my daughter's.
Terms. We are not going to dictate terms. Either you agree,
But-
either you don't agree.
So they are offering the plots, my lordship. My lordship may refer for the mediation if they are ready to pay the amount. They are offering a land.
Sir, we want to know yes or no.
My lordship, we are ready for the settlement, but not.
Just go back, put it on black and white, sign it, end of the matter. And if you say that, no, I am not agreeing to his terms, we'll decide whether he will continue in jail or whether he should be released. It's for you to decide.
And-
A week's time is granted to the respondent number 2. No, she's not a respondent. Respondent number 2, complainant. As paid, released after 10 days.
My lordship.
Take a decision. Take a decision.
Made, please. Regular bail application, I'm in custody since 3 years, 4 months. Your lordships wanted the state to apprise your lordships about the status of the trial. In the counter affidavit, they have filed that of 154 witnesses in total. They have examined 16 so far.
16 have been
138.
examined by the,
He's
it's very,
just a conspirator.
please, it's
Ah,
very
Maybe
well
conspirator
organized.
will also go inside if the offense is proved. But 16 have only been examined, 138 remain.
130.
When will it conclude?
It's a very highly organized and sophisticated organization. Each and every accused has a very specific role. Somebody will buy a mobile phone, somebody will buy a gun, another person will deliver.
Yeah, just for the purpose of, denying bail, we cannot take into consideration this limited role that he furnished, he provided the mobile phone. Leave granted. The High Court of Judicature for Rajasthan Bench at Jaipur, with a judgment and order dated, has rejected the appellant's prayer for bail. Figures as an accused in so-and-so FIR, arrested on 13th December 2022, upon charge sheet being laid on 1st March 2023, and committed to sessions, trial has commenced. 138 are proposed to be examined, only 16 examined.
154 are proposed to be examined.
Sorry, 154 are to be examined, of whom 16 have been examined. So 138 remain.
Yes.
Having regard to the slow pace of the trial and also considering the nature of allegations leveled against the appellant, we are considering opinion that he may be entitled to admitted to an order for inquisition bail. Usual conditions allowed.
Great, great.
Please, madam. Matter is coming after notice, madam. They have filed their reply, madam. They have filed my rejoinder, madam. First,
Your prayer for bail after 6 months.
madam, make two submissions, then I'll make this prayer. My lords, the allegation of sexual assault, my lords. Firstly, my lords, the statement of the girl itself, my lords, initially clearly negates it, my lords. Thereafter, my lords, two medical reports, my lords. Medical report found, my lords, that there is no penetration at all, my lords. Second medical report, which has been now placed along with the counter, says, my lords, no semen detected, my lords. My lords, further, my lords, 183 statement clearly says that she went out, she went on her own free will, my lords. My lords, he is also a 19-year-old boy, my lords. No criminal antecedents, my lords, nothing, my lords. Keeping this boy behind bars also, my lords, in respect to submission, my lord, will not be a keen, my lord, not be proper, my lord.
Simpliciter dismissed.
My lord, may I only pray one thing, my lord? 6 months have already been granted by the learned High Court. That's why I made this submission, my lords. May I withdraw this submission?
If you want, we can allow.
I'll withdraw the.
Dismissed as with.
Please, my lord, I'll make that submission.
In item 7, I am requesting a passover, my lord. Item 7. Passover, my lord.
You just find out from your counter affidavit whether you have said anything as to calling him to join the investigation or not.
My lord.
We did not find it. If
He has already
First.
appeared, my lord. He has already.
in the counter whether they have said or not.
Wait, please, move.
Item 8.
Yes. Now the counter has been filed. And the state counter says 4 antecedents, my lords, in which I was acquitted in 3. And in the other one, which came to be, now it's 13 years.
Very fast paced, Mr. Dave.
My lords, now it's, they say,
80 have been examined, 65 are proposed to be examined further. They have given up several witnesses.
they have, my lords,
No accused is on bail, having regard to the nature of allegations.
but kindly see, my lords,
They have contested the application for bail, saying that
but my lords, may I
should not. Yes,
So I bow down, my lords.
that is their case.
Yes. No, I know your lordships have seen the counter. I'm only saying that my allegation is the same in the other case, which the antecedents are in Tamil Nadu. It's based on the confessional statement of the co-accused persons. I can show the testimonies. 4 out of the 6 witnesses who were supposed to be the prime witnesses, my lords, have turned hostile in their trial. 13 years, my lords, now. 13 years. That has been there. I can show the testimonies. I've put the testimony. Please see the kind of witnesses they have. 80 witnesses for what, my lords? It's based entirely on the confessional statement. The earlier other matter I get bail, it's also based. They say A1 has come. A1 told me that this one was roped, and therefore, my lords, I can show that testimony to your lordships. If there's something substantial they wish to examine, my lords, one can understand that. But to rope in everyone, and they are overlapping accused. They have picked up these persons in the Tamil Nadu matter and in the Bangalore matter. Overlapping accused on the basis of the same modus that accused has told me this on the confessional statement. Please consider, my lords, 13 years if tomorrow Well, from 2013 to as an under trial, my lord. And the only role to me is that this explosive was given to me at a particular point in time and it was taken by another accused after that. That is all that the role is, my lords. It is not the role in any other thing, my lords, that the actual I went there, planted it.
Dismissed trial court is encouraged to expedite the trial.
Those two orders are there from 25, my lords.
If you want, we can impose this 1 year condition.
That it should be within 1 year, my lords. Please do that. Please do that, my lords. That I can renew it after 1 year if
1
it's
year,
not.
yes.
All right. Oblige.
The last occasion, my lord,
30 lakhs.
to ask whether he is ready to pay the amount of 30 lakhs, my lord. Wife is housewife. I'm praying for 2 weeks' time to arrange this amount, my lord. Since 1.5 years he is in jail.
Very well. Released after 3 weeks. Within a period of a fortnight from date, the petitioner shall be free to deposit the fine amount of rupees 30 lakh. Subject to deposit of such amount. You are all appearing, na?
Yes.
The notice is received by Mr. Solicitor, released after 3 weeks.
Oblige, my
Lord.
lord. Highly oblige.
I appear for this state, my lord, my
Very well.
Well,
My lord.
here for the state, we have filed a
Fuentes,
The office
Yes.
report says you have neither filed
We-
wakalatnama nor counter.
my lords, we have filed a counter in Wakalat
Well-
yesterday itself. I'm carrying copies for your kind.
the counter essentially, this is one of the cases where the prosecutor.
Let us look into their counter. This is a NDPS case. We are a bit stiff on NDPS.
All right. No problem.
Counter be placed on record by the registry.
But short day.
Rejoinder may be filed by 5 days, released on Monday.
Next week, my lord.
Monday week. Today we are on Friday, na? Today 24th, 4th May.
Grateful, man. My lords, we have filed the counter, but that is not on record, my lords.
Well, we'll let the counter be brought on record.
Though, my lords,
Continue.
You were saying something.
Next, same date, de na? 4th May. Same order. Rejoinder within 5 days. 4th May, rejoinder within 5 days. 4th May, interim to continue.
order of attachment, that's all.
Not only of restraint, the problem is, my lord, the assets,
Was it out till the matter?
not the problem is, my lord, the assets are worth more than 400 crores.
If it is.
And not the liability is 13 crores, my lord. No, we are not, my lord. As far as
The court
the,
is not going to auction it, the court is not
my lord,
matching it, the court simply says, don't.
my lord, I have to service, my lord, the loan also. My lord, kindly see one thing, my lord. My lord, the total amount of loan was 4 crores. With interest, it is 13 crores. My asset is 400 crores, my lord. 400 crores.
Are you going to dispose them, you want to dispose?
No, my lord, I am saying to the extent of the loan that may be preserved, my lord. To the extent of the loan. But then may I withdraw it, my lord? I may.
Minister has withdrawn.
Yes.
Wait, please, Alaj. There is a delay, my lord, of about 3 years.
So come to your explanation for delay. Page 67.
I agree, my lord. Your lordship may consider,
No, come to page 67. Paragraph 2. Dismissed as time barred.
I am so obliged.
Your lordship, concurrent findings of facts have been reversed by the Honorable High Court, my lord, completely ignoring the law laid down by this Honorable Court, my lord.
Why did you not appear before the High Court?
My lord,
Go and file a recall.
Pardon, my lord?
Go and file a recall.
As well, yes. Your lordship may kindly
Dismissed as,
grant the premise.
dismissed as withdrawn with liberty to apply for a recall of the ex parte order.
Grateful, my lord. As well.
First over.
It's also.
It will go to some 60.
Lord, we are
Yeah,
appealing for the
yeah, let-
respondents.
There's a letter for.
One week, my lord. My lord, similar matter, my lord, just coming Monday. We mentioned yesterday, my lord.
Similar matter is coming on
On
Monday.
Yes.
Listed on
So
Monday.
you didn't inform the other side?
No.
20.
No, both the, if it today's matter and Monday's matter, both the matters may be adjourned.
That both
What?
matters can be taken up together, my lords.
No, then you don't want it on Monday. Item number.
No.
Not on Monday.
Not on Monday, because
Monday.
the difficulties which have,
When do you want it?
next first May.
4th May.
First May, no. First May.
May is a holiday.
No. first,
May is the best day, Mr.
no, my lord, kindly. My lord, that is the day, 4th and 5th, both the days. My lord, I am giving labors for last 8 months. Then the 4th and May, 4th, kindly give me 2 days to enjoy. Celebrate. I have invited few persons there at Calcutta so that I can play the Holi.
Okay. Very well, 11th May.
11th May.
11th May. We'll have a colorful Mr. Bandyopadhyay.
So deeply obliged. Not both on Monday's matter also.
16, 11th May.
Deeply obliged.
Agenda as per letter. Item 18. First over. Similar SLP dismissed.
Similar SLP dismissed, my lords. 19 and 19.1, my lords.
Yes, yes. Item 20.
Should be appearing for the petition. Appearing for the petitioner, Lordship. This is a
Back at that side
No,
window.
your name will be recorded, madam. Same orders.
Same orders. Your Lordship, if your Lordship permits,
Not-
one sentence. I know your Lordship, these are the last 2 matters in the sequence of all 11 which
Right.
were dismissed. Just one sentence.
One sentence, yes.
Is that the respondents, your Lordships, are getting the benefit in spite of having come to the Honorable High Court as the court of first instance, your Lordships, which your Lordships may not permit. Your Lordships, because L. Chandra Kumar's judgment says very specifically. Yes.
Yes. Yes, next matter.
Had that court as an,
These are the last 2 matters remaining.
so
Put an end to it.
that's
Put an
why
end to it.
I sought the
Put an end to it.
indulgence to at least put this aspect before your Lordship. Question of law, your Lordships.
What question of law? We are not going to change our order. Whatever orders have been passed in the earlier matters, we passed these orders because the parent order was not challenged.
Correct.
Once you accept the parent order, we will not. Thank you very much, ma'am.
Please, your Lordship.
Next.
Lordship, this is an SLP against an order passed in a letters patent appeal.
Pending before this court.
Yes, Lordship.
Para 22.
Para 22, yes, Lord.
Yes.
The Madras High Court says that there are judgments of this court that notwithstanding the fact that an order can be executed in accordance with the provisions of law, that does not debar the court from proceeding in contempt. Correct? This is absolutely settled law. Now, if you are not proceeding in execution, you want contempt to be drawn up.
They want contempt. I'm not.
I'm for the respondent.
I'm for the respondent. They are the ones, my lords, who first said we are not even parties to proceedings, went in appeal. The appellate court holds you are not party to proceeding. The order is not binding on you. They come to the Supreme Court. The Supreme Court says matter is admitted, leave is granted.
They come to the Supreme Court.
They also came.
That is not to the interim.
Yes, Lord.
That is why I said para 22.
My lord started by saying so. So there your lordships has said continue to make payments subject to outcome. Now my lords, today what they want is an order which says you are not bound by the copyright board order. They are implying to say that now pay us arrears. That is not
They have to
just a
pay.
minute, that's not a direction.
Lordship.
There is no quantification under section 75 of the Copyright Act. How can
Section
a contempt lie?
75
And my lords, what's the locus? Your lordships have repeatedly said that your right is to bring it to the notice of the court. If the court finds no contempt made out, you have no locus to take it further under section 9.
My question should have been directed to them.
Yes, Lord.
Sorry. So if the court proposes to proceed in contempt,
Lordship.
it can only consider the question of punishment. Under the
Lordship.
Contempt of Courts Act,
Lordship.
the court, on recording a finding of guilt, can
Lordship.
either send him to prison or fine him.
Lordship.
Now, why do we use Contempt of Court Act proceedings as an execution is mainly in writ proceedings because there is no separate procedure for execution.
Lordship.
So we try to twist the arm and get the order implemented without sending the contemner to prison or to jail, prison or fining him. But here, when the court says that I'm not going to send them to prison, but I want these records and calculations to be produced before me. Rightly, it has been interfered with by the division bench.
Lordship, I'll just say two things, Lordship. My first submission is the original order of the court, which is the order against which we are alleging contempt, was an order under Section 72 of the Copyright Act in appeal. That order as such may not be executable because that order...
Planet single judge while holding in your favor says that it's executable.
Lordship, my submission is that...
Will not
Grateful, my lord. Very great.
Lordship may only save limitation because I'll have to take out proceedings. I've spent time in the contempt.
You take advantage of 14.
Grateful.
Lordship may record that in the order, Lordship.
Great. Not record. Yes.
My lords, 21, I'm requesting for a short passover.
Passover.
Grateful.
More or less a similar issue, Murad, arising out of
We'll submit the order copy.
The property was purchased by Bama Balaji in his individual capacity. The matter ends.
Yes, ma'am.
If you're doing like this, matter
No,
ends.
it doesn't end, Murad. There is something more.
No, there's nothing, sir.
There is something more,
Just
not
tell
this,
us.
not this.
Tell us.
But in SLP civil number 16828 of 2025, arising out of the similar dispute between these very same, no, I'm saying not something else. But arising out of the very same business transaction, not similar dispute, this honorable court has referred the matter for mediation. So,
No, for mediation.
let me kindly see this order. But
What property
but
is
only-
own name,
but-
and now we should refer to mediation.
to settle all the issues between the parties.
Sorry.
May I read the order?
This issue only, sir.
May I read the
I'm
order?
very sorry, sir.
May I read the order? Your Lordship, kindly see.
Read it, whatever you want.
May I read the order? Not this order, Your Lordship.
No, no, very sorry.
Only 1 second.
Other case,
Madam, please.
some other property.
Please allow me to say this alone. May kindly consider there are a lot of disputes between these two parties. They are all interconnected. Therefore, His Lordship was pleased to say, Your Lordship, kindly see, the parties have favorably responded to the suggestion of the court that an amicable solution to the dispute be gone through the process of mediation. Let the matter be referred to mediation center attached to the High Court of Madras, Tamil Nadu. Let the parties appear.
Which case, sir?
This is moral dispute between the.
Sir, I will keep this order with us. In all civil cases, we will have to pass that order. What is this?
Not this, but what I am saying is, the disputes are interconnected.
Very sorry, sir.
Only 1 second. Your Lordship, kindly permit
Very,
me.
very sorry.
Only one.
No, we are not going to interfere with concurrent findings.
I do not want Your Lordship.
No, very sorry.
May I take only 1 more minute time? Subject to my Lord permitting. Only 1 more minute time.
Yes, yes.
I am not requesting Your Lordship to interfere because it's a concurrent finding. That is why I noted my head. I got no case. But my Lord, the disputes are interconnected between the parties. Interconnected. Arrangement the same business transfer.
This property is concerned, matter comes to an end.
Yes. Next matter. 23 similar dismissed.
24 barred by limitation.
Huh?
It's barred by limitation.
Time part.
Why? So, I mean, 200 days only.
No, 200 days, but they're 7 years.
7 years.
They're 7 years.
But 156. 156.
6
3 1. Or
3
1
1.
3.
3 1.
3 1.
156 3 1. Direction or finding. But they are trying to use the High Court order.
153 6 1.
That will not come.
That will not come. That will not
Because there's no.
Yes, next.
Very good. Very good.
Same matter.
But have kept the question of law open since
Same order.
pending before. Yes, my lords.
No, we have said having regard to the advanced stage.
Yes.
So here also he is
have the
80 years old. Same.
All of them will
Like
be.
your own people, they are only for 10.
Retirees of 1974, my lord.
Let us give them respect. They dedicated their entire youth
Further,
to this nation.
I'm grateful.
Made people.
You know, I was, Madam Solicitor, I was forwarded a video on a particular group. I found about Bana post. Your Jag would be knowing about it in Siachen. In cold winters, the temperature is minus 80 degree, right? And if they have tears in their eyes, it freezes immediately after it runs down the cheeks. These are the conditions in which our sepoys have been saving our country. Right? These are absolutely those people. So if they, at the age of 80, the sepoys claim some extra pension, give it.
May it please, my lord. My lord, this is the way, my lord, my representation objection has been decided.
That gives you a cause of action for a fresh state
But, my lord, by the time they considered it, it had already become infructuous, my lord. They already.
It cannot be in a contempt jurisdiction. Look into 96(6), you will get the answer. Dismissed
Obliged.
with liberty to the petitioner to challenge the order which has been passed, rejecting his prayer.
Obliged.
Please, my lords. My lords, the Honorable High Court, while determining the nature of the property, or rather determining the stamp duty payable on the property, incorrectly determines the nature of it. And
in the synopsis,
My lord, item number 27. My lord, item number 27.
yes,
Accused don't know
item 27.
victim cash details, my lord.
You are for the
Under section
petitioner or the
8C,
respondent?
my lord.
27, you are for the petitioner or the respondent?
Petitioner and advocate, sir.
But the petitioner is represented here by counsel physically.
Already.
You decide between the two of you who will argue.
I think there must be confusion.
Okay,
as far as that, my lord.
he
It
was
must be for a
argued,
different
sir.
matter.
Must be for a different matter.
Probably, my lords.
इनका नाम क्या है? सुधा. क्या नाम है?
Sudarshan Rao, my lord.
Ajay, what is the cause title of your matter?
SC/ST case, my lord, under the Article 32, my lord.
This is not 27.
Your case must be there in some other courtroom.
Not in this courtroom. 27 is different. Sanjay Agarwal versus State of Rajasthan. This is not that matter.
Please, my lords.
You tell us.
Please, my lords.
In your synopsis from B to E, have you said about this Gulab sweets?
My lords, because that was never in existence.
So where have you said that?
My lords, I'll point it out.
We want that statement.
Please, my lords.
That Gulab sweets is something very imaginary. Nobody is manufacturing sweets. Nobody is storing the ingredients for manufacture of sweets. From B to E, where is your case that Gulab sweets doesn't exist? Show us.
Please, my lords. My lords, if that is the only contention, my lords, we'll file an affidavit to that end. However,
no.
Why I see that,
You
my
must have said so before.
Please, my lords. Before the collector.
authorities. Show us.
Before the collector.
We will not allow you to improve your case now.
Not, my lords, not at all. We are only supporting the case of the collector. Please.
Show us.
My lords, may just come to 36.
36.
Page 36. This.
Any
annexure-
pleading before the High Court that Gulab sweets
before the High Court
doesn't exist.
I'll just show that, my lords. My lords, if I may, my lords, what I may show, my lords, is the pleading before the collector.
We are passing it over. We are
Please, my lords,
passing
we
it
will-
over.
we will
Show us
show
a
it.
specific statement
We will.
in the second call.
Please, my lords.
Please, Your Lordships. Kindly consider to see page 12, which represents Lilavati, my lords. Lilavati, Lordship may see clause 9.
Page, sorry, not page, serial number 28.
28, my lords. Request you to have a look at page 12 of the impugned order, which represents Lilavati, my lords.
Sir,
Yes, my
your
lord.
preliminary objection has been overruled,
Yes, my lords.
right?
Yes, my lords.
So it is sort of rejection of an order 711.
My lords are right. I bow down. Yes, my
Now
lords.
let the proceedings continue. We'll keep your right open to challenge this order when the complaint is decided in favor of the complainant, if at all.
As my lords feel appropriate. As-
Akin to section
Otherwise, my lords-
105 CPC.
Your lordships are right. I bow down. Lordship, I consider recording that, my lords.
An interim order passed by the NCDRC overruling the preliminary objection of the petitioner that the respondent is not a consumer within the meaning of the Consumer Protection Act is under challenge, Mr. Para. At this stage, we see no reason to interfere with the impugned order. The special leave petition stands disposed of with the clarification that if at all the complaint of the respondent succeeds before the NCDRC, it shall be open to the appellant to challenge the finding given in the impugned order if it proposes to file an appeal against such final order.
Lordship may like to say that this issue, I can raise it at the, because otherwise there's no over to
Now there is a finding.
Yes, my lords.
We don't want you to give another
Very
bite
well.
at the
Another
cherry
round
and
of,
raise the same.
Very well, lords.
It is there.
My lords.
We are keeping your right open to challenge this finding.
Very well, sir.
If you come up in a
Lordship may say that in
That's-
the, in
we have
the,
clarified.
very well, sir. Please, sir. For delays of 16 days, Lordship may condone the delay.
Condoned.
Image replies. Grateful to my lords.
Please, my lords, I'm seeking a short passover.
Passover.
Grateful.
But I beg to appear, my lord, if your
Yes,
lordship
Mr.
has,
Mehta, what is this? Your initial notice says that you file your written response.
I want to answer that, my lord, in law. Please have a look at the Consumer Protection Act. Please have, my lord, the notice issued by the registry cannot govern, my lord. What we have to look at is the statute itself. Please have a look at the Consumer Protection Act. And, my lord, there are variety of orders which are being passed, my lord, by different benches. Sometimes, my lord, they admit and issue notice. Sometimes they issue notice and put it for admission.
The NCDRC
Yes.
has said that under the law, on the first day, either we admit or reject. So once it's not rejection, it's a notice case. Presupposes that we have admitted it.
I'll answer that.
And once the notice goes to you with the stipulation that if you are willing, you may file your response within 30 days.
I understand that.
And thereafter you take a stand that.
Please have a look at the act.
What is?
They forgot to file a reply. Sorry.
No, not required. See, 36.
Yeah, that's what I want to show your lordships the act, my lord.
21 days, it's a deemed admission.
No, just 1 second, my lord. Please have a look at, my lord, first, my lord, if your lordship has, my lord, 36. My lord, 36 says, my lord, 36(1), both your lordships, my lord, Justice Dipankar Gupta also has, my lord. 36(1) says, my lord, every proceeding shall be conducted by the President of the Commission. And 2 says, on receipt of the complaint, District Commission may by order admit the complaint for being proceeded with or reject the complaint. Admit. Now please see 38, my lord, the procedure.
Please.
Yes,
read
yes.
that, proviso also, that is against you.
Provide. My lord, nothing is against, my lord. Let me, my lord, I want to interpret the act, my lord. I want to interpret the act.
It's against you.
Yes, my lord.
If it is not admitted within 21 days, there's the deemed admission.
My lord, the question is, my lord, it should be, my lord, the varied orders which are being passed by different benches of the tribunal. I put it on record also. No, but the question is, my lord, just have a look at, my lord, just have a look at 38.
Deeming will apply only if they have specifically said not admitted, then deeming provision will not apply.
Can I answer?
Very well.
My lord, what my problem is that we have given a society, and to reach that society there is no road, and my this will be the quantum of the claim will be around 20 to 25 crores for making those roads and
roads. They want roads to be built.
Yes.
That is Huda's job, not my
and
job.
approval of STP has to be
show the plan, my lord.
20 to 25 crores will be the
to build the roads.
My lord, they have to build the roads. They were the ones who promised it. Now, how can I go to a society where there's no
sector
roads?
road, my lord.
So, my lords, may I also submit one?
We are imposing cost of 2 lakh on him.
My lords, may I? My lord,
We will grant. Look here, a list is to be decided upon giving both parties fair opportunity.
Yes.
Right? We are putting them to terms. 2 lakh they have to pay within fortnight. If they don't pay, they forfeit their right. Within 15 days, they will file their version. We will request the NCDRC to decide it as early as possible.
And we have 49 complainants. My lords, earlier, my friend Mr. Mehta appeared. My lord imposed a cost of 1 lakh per complainant. My lords, that is, my lords, because this is a case, my lords, 10 years we have been waiting for roads, STPs, and nothing has been given. My lords, high-end luxury. My lord, consider 5 lakhs, my lords, because that will.
What is your turnover, Mr. Mehta?
Tata Capital, my Tata Housing there, Malaj. They are Tata Housing, Malaj. They are Tata. OP1 is already expired. They are OP2.
They are occupying since 2014, all of them, my lord. They are blaming us for sectoral roads.
They are
If it is starter than 2 lakhs is okay. They are not like other companies.
Fair enough.
Lord, I'm not even.
Malaj, may consider keeping this matter time-bound disposal because already delay has happened, Malaj.
CDRC has closed the right of the appellant to file its written version. Since no such version was filed within 30 days of receipt of notice dated 17 September 2025. In our considered opinion, this request is decided if the parties are granted full opportunity to present their respective versions. With that in view, we set aside the order of the NCDRC and grant liberty to the appellant to file its written version within a period of a fortnight from date, subject to condition of deposit of rupees 2 lakh with the advocate on record for the
Malaj, may I make one request, one earnest request in this matter to resolve the matter.
to advocate on record for the respondent. Stop. Once the written version is filed within a fortnight from date, if the written version is not filed within a fortnight from date, the appellant shall forfeit his right to file such version in future. We request the tribunal, we request the NCDRC to decide the complaint, consumer complaint in accordance with as early as possible, preferably within 6 months from date of filing of the written version.
Malaj, I have an earnest request in this matter. If it can be explored with Mr. Mehta is here, but we can send it for mediation also before this coming.
Not preclude the parties to explore a mediated settlement.
Lordship, please.
Fair enough.
Your Lordship.
Appeal disposed.
Your Lordship, in the matter, Your Lordship. Lordship, if I may. Your Lordship, in the matter, Your Lordship, the respondent filed a suit for defamation.
Why did you appear?
Your Lordship, we only go to know about the proceedings, Your Lordship.
We
got to know about the proceedings, Your Lordship, very late, Your Lordship, after the contempt.
Go and file a recall.
Your Lordship, may give the liberty.
Either we can grant you liberty
Yes,
to
Your Lordship.
pursue the appeal before the High Court, or you go before the trial court and get the suit for defamation dismissed.
Your Lordship, may give me the liberty, Your Lordship.
We find no reason to interfere with the impugned interim order passed by the High Court. Especially the petition is dismissed. This order of dismissal shall, however, not preclude the petitioner to either pursue the appeal, pending appeal before the High Court for early hearing, or to raise all points before the civil court to have the suit for defamation dismissed.
Milords, I appear for the respondent
obliged.
in this matter. Milords may just say High Court of Kolkata because there are also
High Court has?
High Court of Kolkata because there's also proceedings pending in High Court Kerala. So
Very well. First line जो है ना, dismissed जहाँ होता है, High Court at Calcutta.
great.
Your Lordship, there's a delay, Your Lordship.
Delay
Your Lordship. Obliged.
Let's hear 3 prior policies. Let's not disclose.
Lord, Mr. Sisodia, we'll have to hear.
No, my own judgment is there. I have to follow my own judgment.
Your Lordship's judgment is that these are all immaterial things.
We'll consider. We'll consider.
No, fair enough.
You file your response.
Lord,
you file your response.
May I say? Fair enough, Lord.
Judgment is also there on the side.
The appeal is admitted. 2 weeks for response. Mr. Shishod, who is your advocate on record? You're appearing on caveat, accepts notice. 2 weeks for counter, 1 week for rejoinder, released after 4.
May I say one thing?
Stay of the impugned order.
Lord, may I say for the state?
What was your earning, Mr. Shishodia? That you paid 1.2 as premium?
Lord, he's a businessman.
He's a businessman. He's a
with a rice mill,
businessman.
Lord.
He's a businessman.
With a rice
The order records that when he bought this policy, he was just a matriculate.
No, matriculate can be a business.
No. At that point of time, he was, what was his age?
55. 55.
We decided finally.
55.
Yes. And Lord, he died of H1N1. Lord, it's not after a year.
So a 55-year-old businessman having such a large business does not understand the questions which he is required to fill up in the form as to whether you have any other policy or not.
Assuming everything against
Very
me,
well, we'll consider.
these policies were not taken, Lord. This is what
We'll
has come.
consider.
That will decide.
We'll consider.
But Lord, may I say one thing, Lord? This widow waited for 11 years, Lord. Let the money be deposited here. So it's a money decree.
Very well. What is the total amount? 1.5.
It will come to 2 crores, Lord, with 6% interest.
Just
11 years.
leave aside the interest part. We are just asking about the principal is 1.5.
No, well, the principal is 1.2 crore.
1.2 crores.
Crores was the sum
1.20.
assured. That was 1.2 crores was the sum
Keep
assured.
in deposit 1.5 with the registry.
Very good.
Within a period of a fortnight fortnight would be okay?
3 weeks.
3 weeks. Rupees 1.5 crore shall be deposited by the appellant before the registry without prejudice to the rights and of the parties in the pending appeal. Once the amount is deposited, registry shall invest same in a short-term interest-bearing fixed deposit account and keep it renewed and further opportunities. Next.
And Lord, I may just inform, there were 3 policies. 2 policies were not taken in 2011 itself. This is 2014. 11 itself, 2 policies not taken. Third policy is health insurance policy. This is only for health plan. And this life insurance has nothing to do.
We'll consider.
Please.
Yes, item 33, notice on COD plus SLP tag with diary 53868 of 24.
Deeply obliged, my lords. Grateful.
Please, my lords. Here, my lords.
If the civil court does not have the jurisdiction to decide validity of land acquisition proceeding,
Please, my lords.
Waqf tribunal has that power.
Please, my lords.
Show us one authority, Mr. Hegde.
Let me show you.
Show us one authority.
Let me first show you the act.
No, we have seen from the judgment what
No,
is
it
83.
is not quoted.
What is 83? We have seen.
Please see 51. Please see 51. Just hand over. 51.
Yes.
Read with 83.
You please read it out.
Please, my lords.
Please read.
It's not as if land can't be acquired. Provided further, nothing contained in this subsection shall affect any acquisition of Waqf properties for a public purpose under the Land Acquisition Act or any other law relating to the acquisition of land if such acquisition is made in consultation with the board. Provided also that the acquisition shall not be in contravention of the places of worship, all that, let that be C. No alternative land is available which shall be considered as more or less suitable for that purpose. Now, my lords, here there is an alternate alignment possible. The High Court in its previous order says, please examine whether an alternate area is possible. That is at page 230. Please see that order at page 230. At 232. At 232. Please, my lords.
Page
230 at 232. Para 9.
Yes.
In the meantime, the learned GP who is appearing for the state shall seek instructions from the respondent, the collector and the district land acquisition officer on the points raised in the order in question. Before filing the affidavit, the aforesaid officials headed by the collector are required to visit the spot along with concerned revenue officials as well as the officials of the NHAI besides the aggrieved parties to inspect the plots. The aforesaid officials shall submit a report whether there is any feasibility of diversion on the alignment of the said expressway or not. Then, my lords, another on the next occasion,
yes,
there is nothing adverted to out here. All that the High Court says is, look, there are 2 central acts. The latter act takes over.
We are not on the reasoning of the High Court.
Please, my lord.
We are not on the reasoning.
Please.
Tell us what about the compliance of this order?
Nothing happened. Nothing happened.
Did you not raise before the High Court that there is a previous order where there is
We
no
did,
compliance?
my lord, say it's not recorded.
Where have you stated in your in your synopsis that you did raise the point which the High Court turned down? Where have you said so?
I'm sorry. We have not, just 1 minute. We were not even parties there before the High Court. Notice upon us had not been served. We have said so on TT, page TT. Page TT, we have said, take it down.
Mr. Hegde, perhaps you are not
That is
properly
the
instructed.
objection, my lord.
I'm-
Page 230.
Please,
The
my lord.
first title is there.
Yes,
Respondent number 1 corresponds with respondent petitioner number 1.
we were parties, but we were not represented through counsel. In fact, there is an order which says, please serve them. That also is not complied with.
This order is an ex parte order.
Please, my lords. Insofar as we are concerned, it is. Page TT.
So
At page 235, at
where have you stated in your synopsis that
TT, page TT.
TT,
Yes, my lords.
double T.
Double T. On the date 31st of the order.
Double T.
Yeah, the order, the High Court.
Which date?
31st of
31st
January
January
2026.
26.
Please, my lords. Send copy of the concerned police station with direction to serve the same on the petitioners herein. But no steps were taken by the concerned SHO to serve the petitioners, and the petitioners have never been served in the present case.
Please come to page 4, para 4.
Please, my lords.
Page 4, para 4.
Please.
Finding is inaccurate.
Please, my lords.
The contesting private respondents took part in the argument of the instant appeal.
Yes.
That, my lords, is
One counsel, Mr. Huda, had appeared for them, my lord.
4 to 6.
One
Please,
Mr.
my lord.
Huda has appeared for them also.
contesting one.
Respondents 4 to
For the appel, please see the appearance.
Private respondents, my lord.
That's
Just one. 4 to 6 के लिए advocate साहब,
yes.
Okay. लेकिन
they are 1 to 3.
but others please see para 4. Next page.
1 minute.
Incorrect as per the appearance itself.
The appearance itself is 1 minute.
That's what I'm saying.
Why?
रिपोर्ट कहाँ है रिपोर्ट निकाल
Private respondent is 6.
No, my lords.
If I may assist, Mullah, your lordship is right. It says that in para 4.5, but Mullah will note that in the appearances there is nobody. So Mullah, that finding is not entirely accurate.
No, but where is your specific statement in the synopsis
TT.
that this petition has been disposed of, civil division has been disposed of without notice to us?
Plus, TT is the best we have placed it.
We have placed it.
Therefore, if that be so, go back to the High Court, pay for a recall of the order.
Your lordships would permit us to record our submission.
Mr. Hegel and senior counsel appearing for the petitioners submits that the impugned revisional judgment and order of the High Court was passed without even service of notice to them in terms of the order dated 31st January 2026.
Would your lordship excuse me?
Huh?
Would your lordship kindly excuse me, my lord?
Just, it will end just now, 31st January. 31st January 31st January 2026. If indeed that be so, it shall be open to the petitioners to seek a recall of such order by filing an appropriate application. With such liberty, this.
My lord, sir, on your lordship will just kindly record my submission that we have on behalf of NHI. My submission is that they were also heard through the council, my lord.
Very good. We record the submission of Mr. Sanjay Leonard, Additional Solicitor General, appearing for NHAI, respondent number 1, that the petitioners were duly heard by the court. Uske baad, if indeed.
Great. Good.
Mullah, may I just say one thing? Mullah, your lordships will permit us to come back if necessary. Because otherwise,
Yes,
Mullah,
yes,
I
no,
will.
but that will be open.
Mullah will give me that.
That is always open.
In the event,
Yes.
the application
You're
for
right.
My lord, this will
fails
be
before the
misused
High
by
Court,
them, my lord.
the petitioner shall be at liberty to challenge the impugned order in a fresh assessment.
Yeah, but if we don't write this line, they'll be remediless.
Yes.
No, no, no.
Difficult.
My lord, they don't need remedy because they have no locus. my lord.
That is beside
Mullah,
the point.
state is all powerful. Mullah,
Whether
no remedies
they-
at all.
Unless we grant this liberty,
As your lordship, please.
their right would be closed.
As
Please, my lord.
Mullah, just one more, Mullah. Mullah, the lordships are very kind. Just one aspect. No construction has happened on this.
I'm sorry, my lord.
On status quo, we will not.
Completely incorrect fact. Therefore, they have not brought on record our affidavit before the High Court that substantial construction has
Not
been
on
made.
dispatch at all.
Mr. Solicitor, when they file an application for recall, take all points.
Lordships, deeply grateful. Deeply grateful.
Please,
The status quo won't be. Mullah, your lordships will consider on this.
See, on the case, they have left the graveyard and they have left the mosque.
Yes.
So please,
Huh.
Well, that's what they
Big project, please don't stall it.
Well, no, no, of course, my lord, we won't. my lord.
But it is one of the most ambitious project of government of India, my lord. Amas Darbhanga Road, my lord, connecting Gaya.
Required to be released, they have not, they have released.
Yes,
So
we have
there is a
released that, my
factual
lord.
dispute whether graveyard is being covered. Your lordship is right. If there is no graveyard, there is no reason why we should. There is a factual dispute on that question. Some graveyards are being covered, some aspect is covered. That's the challenge. Because mosque is not, I agree with your lordship, but graveyard portion is being covered. That's the difficulty because there are actually graves beneath that. That's the challenge. That's why, my lord, we are, otherwise your lordship is right. It's a developmental project. Why should anybody oppose? We'll take compensation and go, my lord. That's all. Grateful.
Grateful.
Yes, next.
Please, my lord.
Lord, suit decreed, appeal dismissed, second appeal dismissed, 2021 execution filed. High Court says, my lord, please have a look at page
Realize
81.
that High Court passed a wrong order initially.
No, initially, my lord. Please see page
How
81.
can it be, Mr. Chaudhary?
No, what?
How can it be that after everything is settled, you will give possession? Tehsildar has a right to adjudicate. High Court has not foreclosed the right of any party to
Right,
go up in
right,
appeal
right.
against Tehsildar's order.
Right, but
So now Tehsildar's order was appealed against. Appellate authority has set aside the order of the.
just give me
Tehsildar,
2 minutes,
directed
my
the
lord.
inquiry.
Just see page 81 and I'll show another page, my lord. Please see page 81. Para 36.
Yes.
Yes. The parties have been litigating since 1992. Therefore, to give an end to the proceeding between parties, the petitioner should appear before the Tehsildar to raise the objection to the partition chart prepared by the Deputy Superintendent of Land Records with an undertaking that after the Tehsildar decides the objection and passes an order either amending or confirming the partition, they would hand over the possession of the land allotted to the share of respondent number 6C and 60. That is me. Within
That is
2
what
weeks
we are,
from the order
that
of
is
the
what we
Tehsildar.
are saying.
Yes.
This
Now-
is passed by Judge A.
Yes.
Judge B in session of the contempt finds that this
But
is.
there is another, my lord, what happens is when they, just one page, man, one more page. My lord, when they go to the deputy
go
collector,
back,
they mislead. They say, my lord, we have not been heard.
Sorry.
My lord, only one request, my lord. Now, my lord, again, my lord, it will go further. Your lordship may ask them to decide in 2 months, my lord. That's what the High Court had done.
We would request the appropriate authority to conclude the inquiry as directed by the appellate authority as early as possible, preferably within 4 months from date.
Very good.
Yes, next.
I'm so.
Not before Justice Sharma.
Who told you?
Sab khabar aaye.
I think that.
36.
36.
36, my lord.
I'm seeking a password.
Before Justice Sharma. So it will go before another bench.
37, I'm seeking a password, my lord.
37 Passover.
Please.
Please, my lords. Lords, in item 38, I beg to appear for the state. My lords, only one issue that arises.
58.
Yes, my lords. My lords, we just have the order of which contempt is alleged.
Yes, passed an order.
Yes, my lords, he's passed an order, but now contempt.
Order has to be challenged.
Yes, but my lords, there is a. I'm grateful.
My lord, problem is this.
Which one?
Item number 36, my lord.
Ah, what is the problem?
Going to see the residential house of the petitioner today, my lord.
ये अभी करो तो हाँ? अभी आरोपी अपलोड करो. Notice stay.
I'm.
So in this, the claim enhancement has been sought. Then this, the claim enhancement has been sought on the basis of the 100% physical disability, sir, and non-pecuniary damages part, sir. And that has been already precedent in the, by the bench only. So there is.
You tell us, you say that, come to your list synopsis.
Yes, sir.
High Court failed to award just and reasonable compensation under several crucial heads.
So like in attendant charges.
Which head High Court has?
Yes, sir. Attendant charges, if you can have a
Has been
specific.
given?
Yes, sir. It is 3,60,000 has been given, sir.
Then?
And on the basis of the calculation of the multiplier also, sir, it has been coming to 11,58,000, sir. It is a prima facie I am saying, sir, in that sense.
Interest is there, 8% interest has been given, you will get a substance.
Sir.
Next.
May it please, your lord.
40 notice tagged with diary number.
Lords, may I first point out, I appear in two matters. There are three matters. So it's an SLP against a dead person. They have to substitute.
I was substituted before the High Court.
We'll substitute.
Oh, that's one.
Allow me. No, just 1 minute. MS Bhagwat Prasad Om Prakash is the
Notes
company.
is a firm consisting of 3 partners.
Right.
Quay 2 partners, they have already complied with the High Court order, deposited the amount, 50% withdrawn in terms of the High Court order. Quay, the 3rd partner who has died, who has a share of 36%, he has already been substituted before the executing court. So they should have.
Allow me to say something, my lord. My friend is on caveat. I have to get a chance to say something. Now, my problem is, my lord, High Court says you deposit 50% and they will withdraw it. Now, I have no problem about depositing 50%. This is to that extent a little different from those earlier cases which were on settlement, where we said that you call them. And so here now my problem is the moment this is a 90 acquisition. Today, the interest which I am paying, the enhancement is, my lord, from 30 rupees straight away to 226 rupees. So it's a substantial enhancement. The second problem is possession taken in 1990. These appeals remain pending. Today we are in 26. 36 years of interest we are paying, crores and crores of rupees. Your Lordship may kindly see an order which your Lordships have made at page 188. This is not 1, 2 or 3 persons who have taken.
No, that's on page, Mr. Patwalia.
We will deposit.
Mr. Das is raising a point that
we will do that.
First title has to be amended.
He told us if he
so tell us who has died.
And yes, Mr.
Just give the name who has died. We will request Mr. Patwalia Jr.
That's
under an obligation to put you on record.
So in the second matter, he is the sole respondent.
So my submission is, my lord, that we will deposit, let them not withdraw 50%, let the first appeal be decided. This is what your Lordships have done at page 187. Please see page 187. These are, my lord, various development authorities. The appellate forum was not existing. For decades, these revisions have remained pending. And the state is now burdened with huge amounts towards interest. Every case is crores of rupees of individuals. Kindly see page 188. Now, this was Bareilly. I am now Meerut Development Authority. And there are so many of these cases. It says delay condoned, leave granted. These appeals have been preferred by the Bareilly Development Authority against interlocutory orders passed by the High Court at Allahabad, whereby appellant was directed to deposit 100% compensation amount payable for acquisition of the land, and upon deposit, respondent were permitted to withdraw 50%. When these matters came up for hearing on 10th November 25, after hearing both sides, this court was pleased to say, execution proceedings pending before the authority shall remain stayed, subject to deposit of 50% of the compensation amount with the court. The amount so deposited is directed to be kept in a fixed deposit receipt in a nationalized bank to fetch the maximum rate of interest initially for a period of 6 months. We are informed that Lara is proceeding with the execution in all these cases where interim stay has not been granted. We are informed that during the pendency of these proceedings, High Court has taken up the main case. That being so, when the High Court has already commenced hearing in the main case, matter is likely to be decided. We see no reason to appeal pending, etc. So, my lord, your lordship made the interim stay absolute. Money was to go in an FDR. Now, facts of the first case are 87 is section 4, 87 is section 6 with 17, 90 possession is taken, 23rd January 91, he takes
direct them to deposit the entire amount with the registry.
Correct. We are willing to do that.
Well, there are 2 points. One, this 50% direction has been complied with in execution proceedings. 2 partners have withdrawn. So this they don't point out. 2, your lordships have sustained in the Meerut matter this 50% order, which your lordships would find in the second matter at page 199.
No, in the first matter it is there. Meerut I appeared. That was substantially different.
Look,
everything was already
Mr.
paid.
Patwalia now. Look at the state apathy.
Money be kept in deposit.
Yes.
We'll direct that.
It was 40 years was the acquisition. You make a man suffer.
They are responsible.
1 second, sir. You make a man suffer for 40 years. It's an acquisition of 1987. Section 4 was 1987. And today, my lords, this whatever paltry amount that the man has died. His son is 68 years old. 2 partners, you comply.
I tell your lordships that in 1990, 23 lakhs they took, which was full and final. Then 2 years later, they filed the appeal.
This is subject to section 18. If you have a limitation point, you can argue your limitation point. So, my lords, 70% of the order complied with. Quay 1 partner, you file this appeal without substituting. In number 2, there is just 1 party. He has died. You don't even substitute him. So you want an order against a dead person in the second matter.
If the amount is paid to you without any security,
yes,
and if they succeed,
yes,
How do you get them back?
Let's two points. 50% without security, 50% with security. This is what the High Court has granted. Your lordships have sustained that order.
No.
My friend is referring to Bareilly. We are concerned with Meerut. This order has been sustained by your lordships. At Manoj, page 199 in the second matter. Your lordship's order. And this is Manoj, page 196.
199, the substantial difference was entire amount already stood paid. This is not 199. The Meerut order.
199 in 40.1.
Yes,
Yes.
Yes, Manoj.
199.
199. Please see, Manoj.
Yes, I appeared.
Yes, yes.
This is what we were saying. That
Yes.
it will be-
No, this is pending. This is completely different.
No, once
This is just 1 minute. My friend doesn't know. These are those settlement
Execution
cases.
proceedings may continue, but recovery shall be confined only to the extent permitted by the High Court within the impugned order. That is 50% of the enhanced amount. This is exactly the same order.
But there the enhanced amount was 20 rupees.
Today you take away somebody's property, you don't pay anything.
My lord, this is not fair, my lord. Let me explain the the earlier order. That is a separate scheme, the Shatabdi development scheme. There was a settlement. Under the settlement, people had taken the money. This is a separate scheme. This has nothing to do with that scheme. Your lordship may call for that file for Monday and see both of them together. This has nothing.
But sir, I mean, years they have been deprived.
My lord, it is because of them. The appeals remain pending because of them. We are not to be blamed for that at all. And today, my lord, if 50% is taken, I will give a list of the appeals pending. There are hundreds of appeals. This is a complete bleeding of the state exchequer. This is complete.
But they are also bleeding.
No, my lord. So your lordship may ask the High Court to decide in a time-bound manner, as your lordship did earlier. Once the High Court decides in a time-bound manner, the matter will be finalized. If we pay, we will never recover it back. Now, this Meerut case, which my friend is talking, where your lordship was going to tag it with that, I had appeared there. And let me remind your lordship, my lord, that was a case where under a settlement, they had taken the full amount. And we said we will pay them as per settlement. We have not even got possession.
There is a wrong statement. You've asked for tagging on same grounds. There is a wrong statement made.
Sir, you see, the father is no more.
Correct.
Son is 60 years old.
68 milots.
68.
Yes, milots. They've built a full township, earned humongous profits.
See the money.
My lord, the point is that 20 rupees is made 270. It is complete unjust enrichment. What is happening here is, and on that,
20 rupees was in which year?
my lord, 20 rupees we paid to them on that basis. They took the money in 91, 92, and it was full and final. This gentleman takes it on 23rd January 91. Entire amount of compensation is taken. Full compensation. Please have my list of dates. In all the three cases, after taking the complete compensation, utilizing it, then now they take a second round. In the second round, what happens?
There's a large number of cases for landowners also.
My lord,
And you know the ground.
my lord, the point is,
In some cases have been given peanuts.
my lord, the point here is that
Reference and appeal and all those procedures.
my lord, the point here is, my lord, that this 90 to 2026, 36 years at 9%. Please see the 9% running against us. That is what is killing us. Just see page 162 of the first paper book. Please see page 162 of the first paper book. What is the order? What is actually killing us is, there your lordship said deposit only 50% of enhance.
And they've developed a full
Just, my lord, this running commentary will take us nowhere. Please see page 162. Please see page 162. I have a problem, my lord. Yes, I have a problem, my lord. I am state. Today 50% is 5 crores. Today, 50% of what he's wanting.
Mr. Patwaria, in terms of the present award, how much are you required to pay this third partner?
5 crores. 5 crores is 33%. Now, 5 crore, just 1 minute. 5 crores is 50% of 36%. So 10 crores today has become 36. Out of this 10 crores, the actual compensation will hardly be 10 to 15 lakhs. The rest is all multiplier of interest. And so therefore, my lord, we have sold this land in 90. We have not made crores. Today, these are for economically weaker sections, this colony. And we are totally out. The Meerut Development Authority will go defunct. I have talked to the secretary. He says that if we have to pay all these amounts to everybody, we will have to wind up our authority. We don't have the wherewithal. In fact, in the other case, my lord, where it came before just a different bench, where I had appeared for them, 98 crores was taken away by a person whose land was acquired. This has become almost a scam over there, my lord. These hundreds of, just kindly see, 36% is, just kindly see the attachment order at 50% is 5 crores. But what I am saying is, we will deposit 100% in the court. Yeah, please ask the High Court to decide it finally. I don't want them to suffer, but it should not be.
They ought to be given something to survive and contest the proceedings.
My lord, they are very happily surviving and contesting. They have taken the full amount of 23 crores in 1991. They have taken 23 lakhs. Sorry, 23 lakhs. They have taken 23 lakhs in 1991. In the second case, my lord, the person has taken 12,78,000 without any protest, unconditionally. And in the last case, it is 6,85,000 without any protest, unconditionally at that time. Then there have been so many settlements with them. They came at 165. We said, all right, you even take 165 and go. That also did not fructify. Today, my lord, we have our back to the wall. We are virtually fighting with our back to the wall. I am only saying, my lord, we will deposit this. And in all these cases, our accounts are frozen. We have no money to pay. Kindly see the attachment orders. We are begging, borrowing from the state and paying where the state doesn't give. Our accounts remain attached. In the other case where my friend is talking, the account remained attached for so many years. By the time your lordship could decide it, executing court gave him 98 crores. So it was a fair to comply. And it was shocking for the court also to see that.
After my friend.
So my lord, I am only submitting, my lord, on behalf of the authority, kindly allow us to deposit it. Let them not take it away, or let them take the basic enhanced compensation without interest.
Liberty is granted to the advocate on record for the petitioner, Meerut Development Authority, to substitute the deceased respondent by his heir stroke LRs. Learned advocate on record instructing Mr. Das, learned senior counsel, shall provide the particulars in course of Monday next. First title be amended suitably. Amended memo of parties be filed within a week from date. Having heard Mr. Patwaliya and senior counsel for the petitioner and Mr. Das, we are of the considered opinion that no useful purpose would be served in keeping this special petition pending. The same stands disposed of with a direction to the petitioner Meerut Development Authority to deposit the entire sum as awarded by the reference court before the registry of the High Court within a period of 3 weeks from date. Once such deposit is made, the Registrar General shall set apart a sum of rupees 50 lakh and invest the balance sum in a fixed deposit, in an interest-bearing fixed deposit account on auto-renewal basis and subject to further orders to be passed by the High Court in the first appeal that is pending before it. The said sum of rupees 50 lakh shall be made over to the heir stroke legal representative of the deceased respondent. What is the name? Deceased respondent?
Brahmdat.
In accordance with law. Stop. We record Mr. Das's undertaking that should the appeal succeed, said sum of rupees 50 lakh shall be returned to the petitioner, Meerut Development Authority. Stop. Having regard to the fact that the acquisition dates back to 1987, we request the High Court to endeavor taking up the appeal on priority basis and decide the same subject to its convenience as early as possible, but preferably within a year from date.
Grateful.
Same order in the next
All
matter?
three, then you're.
All three.
Because the only difference is the High Court has granted 50%.
Entire thing is being kept in deposit for the present, for you to survive. You are getting 50 lakh. We have given this direction for Allahabad High Court. We don't give directions like this within a year.
Please, grateful.
In the second case, the total amount is.
Whatever total amount. Whatever is
I
the
don't
total
get
amount.
the third matter, so I don't know.
All,
In some, the second case, the total amount is 3 crores, but in the third case, the
Achha,
total.
you are appearing only in 40.
40 and 40.1.
40 and 40.1 are
Yes.
disposed of. In 40.2,
Is same order. 40.2, the total amount is.
no, 40.2, nobody is there. We can't dispose it of. in
Then your
there.
lordship may just issue notice because there the amount is 47 lakhs only total.
Issue notice.
We'll serve them and bring them back. Your
Issue
lordship will give it
notice,
Dasti
हाँ.
after 2 weeks. We'll serve them.
Issue notice, 2 weeks returnable, Dasti.
Great. Great.
Grateful.
Great.
Lord, conviction has been reversed by the High Court. 583. Lord, I.
No, 583 plus
Plus
100 days
350.
delay in refile.
Please. That,
So it comes
Lord,
to
there is.
83.
Anyway, not on delay, on merits, you don't have it. Allowed. Hey, dismissed.
Lord, on merits, my Lord,
No.
if I may only just point out one aspect.
Money not paid and the application is scrutinized, then the
No, my lord.
surveyor is appointed,
My lord,
then PW3 and
if I
4,
may-
they don't tally.
My Lord, if I may
Leave
just
it.
point out section 7
No,
of the
no,
PC
leave
Act
it,
as it
leave it.
then stood, my Lord.
Concurrent acquittal.
No, my Lord, the trial court had convicted and it is a reversal, my Lord.
Reversal.
My Lord, section 7 at that time, it provides, it includes these cases also where, my Lord, even without an application being pending, what happens in these situations, my Lord? They say that
Will I
I'll get your
conduct?
work.
Next, 42.
Please, Your Honor, in this, the conviction has been upheld by the Honorable High Court, Your Honor. The insanity. He was insane. His act clearly showed. A sane person would not harm himself and would not cut his private part, Your Honor. That's the reason I'm saying, Your Honor may consider that fact that,
Out of break, I was going. 313 is 313 statement.
please, Your Honor, that he 313 clearly admitted, and what I want to submit that if Your Honor may consider the circumstances.
Delay condoned, dismiss, almost 10 years. Superintendent to move the government as and when he acquires eligibility for premature release.
Grateful, Your Honor.
अच्छा, वो 40
My lord, because you don't know.
आपका पहले आप अपना
My lord,
आपका नाम क्या है?
Chinchili and Sudarshan Rao, my lord.
सुदर्शन राव जी, पहले अपना कैमरा प्रॉपर कर लिया, आपका चेहरा भी हम देखना चाहेंगे. यस, हाँ.
Chinchili and Sudarshan Rao, my lord.
Yes.
Petitioner,
Why can't you move the High Court?
sir, my lord.
Why don't you go to the High Court?
High Court means High Court rejected this case, my lord.
Where is the order of rejection?
And that rejection has to be challenged.
Already,
Without
already,
challenging
already
rejection, you
filed
can't
in-
file a
filed in-
WP under 32.
filed in High Court, my lord, but the High Court rejected, my lord.
Where is that
A
order?
lot of pending case and from 4 months, my lord. This reason I filed in.
There is a rejection, you have to challenge the rejection.
They rejected in scrutiny SR stage, my lord.
Sorry.
This case is go to before bench, my lord.
In this writ petition under Article 32, petitioner challenges an FIR. He is also seeking other relief, not connected with the FIR. We find multiple causes of action having been espoused in a single petition. When queried as to why the petitioner has not moved the High Court under Article 226 of the Constitution, he submits that the High Court has rejected his petition. Such order of rejection is not the subject matter of challenge. In such view of the matter, we find no reason to entertain this petition under Article 32 of the Constitution. This order of dismissal shall not preclude the petitioner to challenge the order of rejection in an appropriate forum in a
For the petition in this matter, Your Lordship. The Honorable High Court.
You have been dealt with great leniency.
Your Lordship.
You have been dealt with great leniency. Only 1 year.
Yes, Your Lordship.
Only
3 years.
From
Years
three-
down to
No, but
Motorcycles recovered from your house, your professional.
no, Your Lordship. I'm not a professional, Your Lordship. I'm having electrical shop, Your Lordship.
So you,
that is the cover up.
No, Your Lordship.
That is the cover up.
This is not the cover up, Your Lordship. Even I was not at that point of time, I was not there, Your Lordship.
is there. 45 days.
45 days, Your Lordship.
45 days.
I've undergone 45 days, Your Lordship. 1 year punishment, I have undergone.
My lords, in 45, I'm appearing for the petitioner, my lords. My lords, my complaint was dismissed on the ground of delay, my lords. My lord, oblige, sir.
6, I'm requesting for the Passover blocks.
Passover.
I'm praying for a Passover.
Can we tag it with criminal SLP 4141?
Yes, my lord.
Very good.
Obliged.
Notice SLP, notice on SLP, tag with SLP criminal 4141 of.
Obliged, my lord.
Lordship, issue involved in this case is covered by Lordship judgment, which I annexed at page 18, where under NI Act, complaint was dismissed. The petitioner in that case applied for leave to appeal, which was rejected. Then Lordship said he is being victim of the crime. He has the right to file appeal under section 372 proviso, and in that case that liberty is given.
Grateful. May I please, Mills? Because what has been done in this case, Mills, that I have got the 50% sentence has been undergone, and I am getting release from the subordinate courts. Despite of that, Mills, my employment is at stake, Your Lordships. I'm directly hit by Article 30.
482 in this circumstance. How is your 482 maintainable before the High Court?
Mills, because the revision has, in the revision I did not get that reformative justice.
No. 482 court will advise the government that this is not this is an honorable acquittal or not an honorable acquittal, therefore you don't take action against him. You have been dismissed from service, go and file a departmental appeal.
Mills, I've been dismissed.
Your 482 was not maintainable at all.
True. That's my one humble submission. That's point is that I'm getting a reformative justice since from all the subordinate courts. So I'm only praying that any stringent condition may kindly be imposed. Let my employment.
How can we do it? You have been convicted, rightly or wrongly. You have been convicted. You don't challenge the conviction.
No, I have challenged that. I challenged it, and I have.
That's gone.
Well,
Thereafter, did you challenge the upholding of the conviction before the Supreme Court? You didn't.
Well, I have challenged the conviction. That's the point.
Well, your first order you have not challenged. Thereafter you were dismissed from service. After your dismissal from service, instead of challenging the order of dismissal, you again go before the High Court under 482.
Well,
so we are asking you, where is the question of going to the High Court under 482?
Well, this is not what the case is. The point is that they are not reducing my sentence. My sentence has been reduced, that to 50%. But despite of that,
So you are convicted. And therefore rightly dismissed from service.
But Millet, in that
sentence is reduced.
Mr. Counsel, please come to page 1 of the order.
Yes, Lordships.
CR number 1807 of 2024. Against this order, was any special petition filed?
No,
so don't say that what we are saying is contrary to records.
No, that's not what I'm saying.
We can say that we read more than what you know.
My apologies.
Junior counsel, don't See all these things that we don't come without reading our files. Everything is noted. And everything that I've said is according to what the High Court has recorded.
I beg your pardon.
And you don't know what your remedy is. Advise your client appropriately that it has been reduced to the period undergone. This was not such a heinous offense for which the dismissal from service was warranted. Go before the appellate authority.
That much liberty may kindly be granted, much.
Here with the impugned order of the High Court, since the application under section 482 CRPC was not maintainable in the first place. Stop. Remedy, if any, of the petitioner lies in approaching the departmental appellate authority with a challenge to the order of dismissal from service. With such liberty, dismissed.
May I please your lordship? Lordship, High Court convicted this NDPS Act in 5 years. This High Court reduces to 2 years, my lord.
You have undergone 1.5.
I have undergone 1.5, my lord. But question is, my lord, this strict compliance of this section 50 and will not.
52A.
Yes, my lord. And my lord, on page number 11 of the impugned
This
judgment.
judgment. Narcotics Control Bureau versus Kasif. Have you gone through it?
My lord.
Ian will.
My lord, sir, that I can only say that 6 months, this person basically is a student, my lord, 22 years old, my lord.
That's another point.
That's
But,
22 years old.
As per this judgment is not applicable.
That I can understand, my lord. But, my lord, that he has undergone 1.5 years. He's a 22 years old, no any other records of this type of, my lord. No any criminal history like this. Minimum is not there. Minimum is not there, my lord. Minimum is not there, but this up to 1 lakh rupees fine. Yes, yes. My lord cannot say, just undergone sentence 1.5 years.
You have no other antecedents?
No, nothing, my lords. And even this was found.
There is a student, he is allegedly a student, and that he has no criminal issue not limited to the question of sentence, returnable in 2 weeks. Standing counsel.
My lord, I'm sorry, nowhere is mentioned student, I'm sorry. Another case, a student is not mentioned, but if he is 22 years old. I don't want to say anything which is wrong in the court.
2 years old means he may have crossed.
Yes, this
his
is 22
student
years.
age.
22 years old.
Leave it. You said he's a student.
Yes,
you want
in other
to give
case, I've just
a student another chance. Then dismissed.
My lord, 22 years old, but
Another-
that was not found in conscientious possession of this.
Another few months are left. Be the
That's
guest of the state.
Conscientious possession was not found, my lord. The everything was recovered from the car.
No. We would expect counsel to be absolutely ready. Don't say something. Which
No, yes, my lord, I was in the other
when
matter.
first we issue notice, and after we dictate the order, you come and say that there is nothing. Sorry. Next matter.
Very well. Delay may be confirmed.
Delay condon.
Please, Lordship. Lordship, kindly see annexure P1 and P2, Lordship. I have repaid the complete loan 2 years before.
You may have repaid it, but there are
Not only repaid.
forgery.
Lordship, but before 2 years before the registration of FIR, Lordship. FIR was registered in 2020.
Now, if it is found later on that there are forgeries committed by you,
Lordship,
this is an offense
I am an
against the state.
innocent. I am an innocent borrower, Lordship. I am an innocent borrower. There are, Lordship, there are agents that I am trapped with the hands of agents, Lordship. Lordship,
Sorry.
allow me to withdraw with the liberty to file discharge application, Lordship.
With liberty.
The charges have not been framed.
With law. Next.
Lordship, I'm just requesting.
See, again, you are appearing in the wrong place.
I'm just. I'm
Decide either.
One won't have choice to appear in which matter.
It's not your fault.
Lordship, I'm just humbly requesting today's accommodation to be a better prepared if Lordship are prima facie just.
Paid by Mr. Patil, adjourned for 2 weeks.
Great.
Similar matter, my lords.
Oh, I see.
Well, it's, on last occasion, my lords were
Yes, you're
looking.
right. Cannot be because of service.
Well, it's page 108, my lords were looking at earlier. We have filed the RMB proceedings. Kindly come to,
With full respect to everyone.
we also.
No, I'll tell you. People in RMR just write hypertension attributable to military service. And large number of doctors are getting this disability pension.
Well, it's 34 in this
No, you do
particular.
have a case.
Yes, my lords. 34 years of service, colonel.
No, we wanted to know about page 108.
Yes, 108. 108, kindly have my annexure 810, which is at page 26.
We wanted to know who has given this certificate.
This is wrong typing. That is why I have
Wrong typing.
Yes, it says that it's attributable to military service and aggravated. Whereas the original that we have filed at page 26, it strikes off the. Let's kindly have my original RMB proceedings.
One zero.
Yes.
Where is the original?
I have filed the RMB proceedings. Kindly come to page 26 of that.
26.
Yes, this is the pension certificate where attributable and aggravated are struck off and NANA is written, neither attributable nor aggravated. Well, it's, the typing was.
No, why is it that Union of India files, you need to keep the typists occupied, that is why you get it done.
Ideally, they should
In
not have.
all matters, even the impugned judgment, if it runs into 100 pages,
It's not
you ask the typist to type it. Why don't you give the photocopy?
It's not required. Well, nowadays,
And now
all
see
the
what
high courts have got such good printed orders.
Right,
You can
it's
keep that.
not required. This is only in Union of India files that we find.
I will have to write to them that it's not
Time
required.
cost. We have been telling every solicitor who comes before us, why do you take the trouble? Ye karne ke liye, you're a stenographer.
When you go to a military hospital, you'll find at least that. Something like 50 to 100 gardeners. So I asked the CEO that, why do you have so many gardeners? He said, no, sir, they are patients. And they have been told to work because if they lie down, they're army people, they have to work also. So we provide some work to them.
Well, but this,
same with
as well
this
as
one
these
also.
hypertension and diabetes, this is being looked into, my lords. There's a matter which is
At page 26 of the additional affidavit filed by the, we find that the petitioner was, we find that the respondent's ailment is not attributable to and or aggravated. To and or aggravated by military service. Issue notice.
I'm so privileged. Can I ask for something more, my lords? Can I ask for a stay as well?
If we find that a case is meritorious enough for issuance of notice, grant it without the
Yes.
council asking.
I'm so deeply obliged, my lords. Grateful.
My lords, though in a similar matter, your lordships have dismissed the SLP, but it's for a different village. Though for the same project.
We have issued notice?
No. Your lordships have dismissed the other cases, but it's for a different village, so I can just make one.
Thank you.
My lords, I request the Passover.
Passover. 55 partial.
Lord's letter was agreed.
Wait, please.
May I please, Your Lordship? May I please, Your Lordship?
The problem is that people don't tend to. Yes.
Yeah, may I please, Your Lordship? My lord, in identical matter, my lord, notice has been granted, my lord. An interim protection has been granted on 9th April.
This is the same FIR, my lords, co-accused, my lords, is.
Notice has been
issued, my lords. However, there was no date given in that matters. My lords may fix a date. Wait.
Interim protection.
Wait for.
My lord.
Please, my lord. My lord, it's a mem travel offense. I'm ready to join investigation. But despite asking the opportunity, available.
But you were given notice, you didn't join.
My lord, I was not in town. Reason being, I missed that opportunity, my lord. Subsequently, I have got my NBW cancelled.
So if you were not in town and when this is being assigned as a reason by the High Court, you could have immediately pointed out.
My lord, that has been
pointed
my
out
lord,
that you were outside, out of station.
my lord. On the basis of the status report that has been, what happened, my lord, in September, the FIR got registered. The accused persons, they have been arrested in month of October, my lord. Subsequently, I have sent that notice in the month of December. IO was having knowledge that he was, that is.
Yes, madam.
Your Lordship, I'm appearing on behalf of Nunat ASG. We need to take instructions in this regard.
Since you issued a notice under 35, therefore, at that point of time, there was no need to arrest.
Yes, Your Lord.
He says that he was out of station. We'll grant you the liberty calling for investigation. Right?
Interim protection be granted, my lord.
4 weeks, 2 weeks for counter, 1 week for.
And my lord,
Right, Your Lordship.
IO has to examine me in the hospital. I met with accident on 17th of April, my lord, and admitted in Agra hospital.
What disease?
My lord, my elbow has been ruptured, my ankle has been dislocated, so that is required to be reconstructed, and I would be admitted for a period of 2 to 3 months, my lord. So if they want to investigate, my lord, they have to investigate
Your
in the
Lordship,
hospital itself. These are the photographs of.
Your Lordship, if I may.
What is it's a fracture or what?
No, it's a complete damage, my lord. These are the photographs, my lord. Complete damage, and it will take 2 to 3 months, my lord. On 17th itself, my lord, when I was.
Nowadays, medical science has advanced to this extent that elderly people whose knees are operated, they are discharged within 10 days.
My lord, if that would be.
Here, 3 months.
My lord, it's my lord, my lord, if that
there is
would be
evidence
10 days.
also against him.
He's out of station. Now, when we give this interim protection, uske pehle jaake baith jao.
No, my lord.
He can go to the police station with the sling.
My lord.
वो पुलिस स्टेशन जा सकता है.
Through ambulance, I can come to join in. I will join, my lord.
You join.
I will join.
Yes, next.
Right, Your Lordship.
Highly obliged, my lord.
May it please, Your Lordship. Lord, an application for anticipatory bail. Lord, the petitioner is ready to join in the investigation. Unfortunately, my lord, he has been named only as a conspirator on the basis of a case which was decided in my favor, my lord, 6 months back. Now, the police is not looking into all that, my lord, and I apprehend arrest. That's my problem, my lord. Then in that case, my lord, my instructions are to withdraw the application.
Dismissed as before. Next.
I succeeded before the trial court as well as the appellate court. High Court, my lord, frames questions of law. My lord, in the second appeal, Your Lordships will find, my lord, the questions are at page 9 of the judgment of the High Court, para 8. But the High Court does not answer any of these questions. Says the appellate court had entertained additional evidence without oral evidence. Therefore, the matter has to go back. But the appellate court, while entertaining additional evidence, specifically records that evidence relating to those documents which are electricity bills is already there.
The first appellate court, was this additional evidence considered?
Yes, my lord, the learned judge considers
It was
it.
marked in the course of the judgment.
It was marked as exhibit.
Exhibits by the judge suo moto, my lord,
So
without my
if
consent.
if you say that you will not rely on the additional evidence, right?
Yes.
Then the first appellate court judgment touching upon the additional evidence has to go.
Well, nothing touches upon that. Nothing touches upon that. Please see paragraph, my lord, page 167, paragraph 26 of the trial court, appellate court's judgment. The learned judge very specifically says.
Please come to page E of your synopsis.
Yes.
Page E of your synopsis. Third line. If this is your case, why did you file this application at all?
Well, there was a question in cross-examination.
You have seen this, what you have stated?
Yes, my lord.
Then you should not have filed that application at all.
Yes, my lord. This application was taken out only to file, to show that I have been in possession in addition to what has already been done. My lord, may I only draw your lordship's kind attention only to, my lord, only to the time frame, my lord, for the appellate court.
Already fixed, my lord. It gave 3 months. In the judgment, it is there.
You are not in fact to interfere with the order of remand. Next.
My lord.
But this at yesterday's matter.
Yesterday's matter.
Yes.
The this volume page 503 heads, you know.
And once.
Lord, I beg to appear, my lord, for the.
Is an IAS officer or an IPS officer?
IPS officer.
Where is the third volume? Huh? Sorry. Come to page 5. Look at your affidavit.
This one instructions placement.
Written instructions on behalf of respondent Hydra.
Yes.
Paragraph 6. Very well. You have undertaken pre-monsoon works as the subject matter is pertaining to a water body. Works being carried out to prevent inundation and flooding of neighboring colonies. If you have done this, you are absolutely within the purview of the order. You have not committed any contempt. Come to para 9. It is further submitted that the state of Telangana festival of so-and-so is celebrated by praying to so-and-so, took place as part of festival. How do you allow that? How do you allow? Now see, para 11. Subject property is a natural water body and the state is bound to protect the same as possible. Hydra has taken up restoration works as per orders of Government of Telangana. Here, Government of Telangana's order will have precedence over a judicial order.
No, it won't.
Mr. Reddy,
I've noted this.
we are not at all
I'll answer.
satisfied.
Lord,
We are not at all satisfied. We will stay the finding of contempt for the present, but you will have to restore it to its original position.
just one or two short
This is not
submissions.
done.
But after,
You cannot take law in your own hands.
yes, my Lord, Lordships may just give me 1 minute. But I understand what your Lordships have put.
You respond to its position.
But I just wanted to place two facts. But I mean, your
There is no
Lordships.
charm in sending any bureaucrat to jail.
Yes.
But we want the order of court is there. If you have not challenged that order, you are bound by that order. The court accepting your claim says that, yes, whatever is required to be done to stop inundation, to stop flooding, you do it. But you convert it into a park, you allow festivals to be there, and then in 503 you say that I am doing it because government has directed me.
No, my Lord, that
This is above government or the judiciary.
no, there can never be a doubt about it. May I just place two facts, my Lord? My Lord,
We want the property to be restored to its
my Lord, no difficulty, my Lord.
position as on 12th of June 2025.
My Lord, we'll be bound to do it. I'm just requesting for 2 minutes, my Lord, just to explain a few facts. If your Lordship still think that is the only thing that needs to be done, my Lord,
Yes.
we are anyway bound to do it.
Yes.
My Lord, first, my Lord, if I may just, my Lord, I don't want to show the pages. A person claiming 7 acres of land, this is a large tank, my Lord. The total extent will be, my Lord, I do not know the exact details. I'll place it, my Lord, but it will be a much larger area. He makes a claim in respect of a small part of this area, which is 7 acres of land, says that it is private property. He claims under an agreement of sale after his vendor has come to the court and a division bench held he has neither title nor possession, the vendor. This person, after purchasing, files a writ petition. My Lord, a learned single judge specifically holds he is not in possession, he cannot be said to be the title holder. Court says, but if you still have a claim, go and file a suit for declaration and injunction. File a suit, civil suit. He goes and files a suit for perpetual injunction saying, I am in possession. Injunction petition dismissed by the trial court saying, he has not been in possession. Records disclosed from 2014, he has been issuing notice that there are trespassers and is not in possession. And on the suit, my Lord, when the injunction is passed, he has filed one document, Exhibit P35, which specifically records that he is not in possession. Hydra has already put up its boards.
Reddy, when will you restore?
But only one
We
more.
are dealing with a contempt matter. The jurisdiction scope is limited. We don't want to know about the history geography. That will be decided in the appeal.
Just one point.
Whether he has got an injunction, not got an injunction, owner, not owner.
Very well.
The matters.
No, my Lord, only for explaining the
You
order.
ask, when will you restore the property as it was on 12th of June?
One, only for explaining the order, my Lord, not to give the background. My Lord, when the application was filed by him before the High Court, the injunction he sought, my Lord, at page 425, your Lordships may see just page 425. Not only 1 minute.
Dismissed.
No, my Lord, I'm sorry. My Lord, I don't want to. Very well. My Lord, then may I make one request? My Lord, the restoration, my Lord, the High Court directs is in two parts. One is, my Lord, anything that indicates that Hydra, my Lord,
Paragraph 17.
my Lord, page 33, 32, my Lord. Lordships may see both. I have only one request to make, my Lord, and I'll fall, my Lord, I'm bound by whatever my Lords think is the appropriate thing to do.
Page 33.
Lord, page 32, para 69 and 70, my Lord. In 69, my Lord, it requires that entire fencing.
You carry out 69 and 70 for the timing?
69, I mean, it will take hardly 3-4 days.
My Lord,
And this is 70 is also same thing. You take down the
Signage
structures and signages and any other construction changes made to the land, which is the
including fencing, boards, etc.
That land is under the control of Hydra. 69 and 70, these are.
I'm only requesting, Lordships may say, confined to the 7 acres claimed by the petitioner. It's a larger extent where fencing has been done. No, my Lord.
To that, comply with 69 and 70 and report compliance.
My Lord, my Lord, I'm only saying, whatever the petitioner is claiming, my Lord, Lordships may just see these photographs because the very large lake.
Go back to the High Court and face the proceedings.
No, my Lord, I will have to remove the entire fencing throughout the lake otherwise. I don't want to be seen as being in contempt, my Lord.
You should not have done it taking advantage of an order which only permits you to take steps for prevention of flooding and inundation. You could not have fenced the entire thing.
No, my Lord, fencing was outside the controversy.
Either you do it or you go back to the.
No, my Lord, we will do it. My Lord, there can be. My Lord, then may I make only one request? Only for reporting the time within which we will do it, can your Lordships have it on Monday? Not for arguments, my Lord. Only for that limited purpose on Monday.
You do it by Monday?
My Lord, I'll just take instruction because they may have to do it little. Yes. Only for making those, sir.
Mr. Reddy, learned senior counsel for the petitioner at some length. wish for time till Monday to return with instructions with regard to the likely period required to comply with the released on Monday.
Grateful, my lords.
Let's appear for the
Yes,
petitioner.
next.
Let's appear for the petitioner, my lords.
66.
66, my lords.
3% attendance.
Yes, my lords, but I have
What
completed.
I have? What I have?
No, my lords, I have.
What I have?
I have done the
That is no
internship.
ground, sir.
No, but my lords, may kindly see.
Come out a better lawyer once you.
No, my lords, may kindly
Okay.
understand.
Take the
My
exam.
lords, it is only this
He
semester
will
that.
not allow it, sir.
No, but my
This
lords,
will be a precedent if Supreme Court allows somebody with 3% attendance to take the law examination.
no, your lordship, but my lords, I have been doing internship and I have been granted. I have intimated the college.
Yes.
College never objected. My lords, may kindly see Delhi High Court has
Sorry.
laid guidelines on this. That in case there is a problem, they may reduce 5%.
He
my
could have
lords.
understood if it is a borderline case.
Yes.
55% or 65% is the minimum. You have completed at least 50%. Huh?
My lords, but I was interning. That is also
Sorry.
part of legal education
Sorry,
itself,
sorry.
my lord. Grateful, man.
In fact,
Well, it came very late last night. What is the matter? It's come from another bench.
oh, I see.
Uh,
Well, as the wetter this is a coffee estate, Malad.
We found this.
Yes, your lordship looks at that coffee estate. The exemplar that is applied is from conversion of agricultural land, Malads, agricultural land, Malads, to a developed land, Malads. And the judge says now we will apply it backwards, that we from this coffee estate to paddy land. Malads, you can't apply that because it cannot be converted into paddy. So, Malads, that is why we had placed this before the bench, Malads, last time. Malads, this can't be converted into paddy. That exemplar itself is wrong, Malads. And they have relied upon a judgment of the DDA, Malads, agricultural land converted into DDA land, Malads. So all that we want is, Malads. Deeply obliged.
But the notice has been issued. The case is
No, not been issued, Malads. Deeply obliged.
No, when he said notice, so I said, notice okay. It's not the notice.
Your lordship, I appreciate that. Yeah.
You are appearing for the estate? Look.
It ended.
Petitioner has.
My lords asked whether he was cooperating in the investigation or not, my lords. My lords,
Has he joined investigation?
my lords, no notice has been sent to him till date, my lords.
No, no, no. He has appeared on 1st April, 17th
Granted you
April,
that
18th
liberty.
April.
You don't take that liberty.
My lords may fix any date
No,
of
just see
particular.
our interim order issuing notice,
Right, my lord.
paragraph 4.
Right, my lords.
As per,
This is our template order.
My lord.
That protection is subject to joining investigation. You don't call him. That means there is no requirement for custodial interrogation.
And he come whenever you will call him.
My lords,
Charge sheet has not been filed.
no, my lords. Investigation is going on.
Allowed
My lords,
with
may
that
just-
condition?
A small
With
request.
that condition that as and when the IO calls upon the
My lords may fix any date, my lords, so that he could.
It's up to you.
Oh, my lords, yes.
It's up to you.
Great lordships, great.
Your Lordship. Your Lordship,
Go before the jurisdictional high court and challenge it. It's a revisional order.
Your
In
Lord,
terms of SAMPO, universal SAMPO.
Universal Sampo.
We are granting you that liberty.
Highly obliged.
Withdrawn with liberty to challenge the revisional order of the NCBRC before the jurisdictional.
Highly obliged, Your Lordship.
Please, my lords. My lords, it falls under exceptional case, my lords. My lords, it falls under exceptional case, my lords. My lords, there is a delay of 5 years.
You argue your exceptional case before the
My
high
lords,
court.
my lords have total direction, my lord, discretion to hear the matter, my lords.
We are granting you liberty to approach the jurisdictional high court. Appellate judgment.
But my lords, 5 years has been lapsed, my lords.
Then simple.
And
don't take the liberty. We are dismissing you.
then my lords withdraw. I will
Whether
take a
we-
liberty, my lord.
If you don't want it, we are dismissing it.
No, my lords, I'm so sorry, my lords.
Then take the liberty. Yes, next.
My lords, your lordships are considering this issue, my lords. It's pending before your lordships. All advertisements who are prior to the notice.
But Madam Bhatti, I find this order to be very clear. If they are entitled, give it. If they are not entitled, don't give it.
My lords, it is
2003 is the cutoff.
no. Here the issue is different. They are not falling in the cutoff. We have the cutoff. We have ourselves issued an OM.
They are not falling under cutoff. Just write them a letter that 3rd of March 2023, 2003.
2003.
Right? What is the date of the circular?
My lords, the date of the circular
3rd of March or 7th?
3rd March 2023.
Third
Next
of
P5.
You are not covered by 3rd of
My lords, this will not fall in the question of cutoff. This will be in the second category where the court has said that all central armed police forces are akin to defense forces and defense forces have been kept away from NPS. So that conclusion your lordships are considering. On cutoff, we are not even coming before your lordships, my lords. That is, your lordships are considering, my lords. May I hand over this order? It's mentioned in the office report. Your lordships have issued notice only and stay only to that extent that defense has otherwise been kept away from the purview of new pension scheme, my lords. High Court goes on to say that central armed police forces will also be are akin to defense forces and therefore, so only to that extent we are here, my lords. On cutoff, there is no difficulty. We have clarified it, my lords. Your lordships will see the impugn order only follows the earlier judgment. The earlier judgment is annexed, my lords, at annexure P10, my lords. And the second issue is qua CAPF that your lordships will find at page 343, my lords. Para 26. It starts here. Page 343, my lords.
But Madam, what is this? Is union versus. This is another one.
Yes, my lords, it's pending before your lordships. It's only on this issue that, my lords, we are before. So your lordships may consider passing the same order and having it with that, my lords. It is our contention that defense forces, army, air force, navy are at a different, my lords, they can't
But
be.
this order also says that those who have been appointed prior to a particular date, they will be entitled.
Yes, that your lordships may note, my lords. I have no difficulty with that.
Same order, please.
I am very grateful, my lords. My lords, Pavan Kumar was only on the cutoff. So the impugned judgment deals with two aspects. One is cutoff and second is this, my lords. On cutoff, we are not bothering your lordships, my lords.
But this 1-4, this order says.
Yes, my lord.
Tag with 14864.
Yes, so Pavan Kumar has gone because Pavan Kumar, I brought that those orders.
So therefore, that tagging will not be required.
Yes.
We will tag with this one.
With this, my lords.
tag with 33577.
Because in Pawan Kumar, we took liberty to go in review for the cutoff and Malads.
33577 of 23 with similar interim order as the last paragraph.
I'm very grateful, Malads. Malads, we have impugned 2 orders, therefore there is delay. The review order, there is a small delay, but the main order, and our review was delayed by 46 days. Lordship may consider condoning or
Notice on delay process.
grateful.
Please, my lords. My lords, we are grateful that my lords gave us this opportunity to come and assist. Now, my lords, may come to Annexure 10, my lords. Page 102. This is the pleading before the Honorable High Court, my lords. The relevant part falls under on page 109.
109.
Please, my lords. Now, my lords, para 7 is where it is relevant. My lords, I'll start reading if my lords permits. That after receiving the notices, the petitioner filed reply to the said notice stating that the residential house number so-and-so situated at Aravali Vihar scheme of Rajasthan Housing Board, which was allotted to Shri so-and-so on lease and was used of the said residential house, was neither changed in commercial nor used for commercial purpose, nor for any commercial activity run in the said house, nor used for storage. We further clarify the AIG report also here, my lords. In the inspection report of AIG, mentioned that the said property is used at Godam by MS Gulab Sweet in Bhiwadi. Neither any firm in this name of Gulab Sweet nor any shop in the said area. We clarify this, my lords, to this extent. Now, this is also taken note of.
After, if they come with records to show that Gulab is issued a license under the relevant law, Shops and Establishments Act and all these things.
Please, my lords.
And if it is found that Gulab has the same address as this, you know, whatever penalty, only 41,000 or something like that.
Please, my lords.
Huh?
My lords, I understand what the
Not only
consequence.
double it, we will make it triple and even
What
more
we
higher.
understand, my lords, I understand the consequence of misleading the court.
You will have to accept this.
Please, my lords, we understand that consequence. My lords, now, my lords, whether this.
We will record this. We will record that you have invited our attention to page 109.
Please, my lords.
And after if they come and show that this is wrong, we'll have it.
My lords, no trouble with that, my lords. If whatever the consequence of that will be, my lords, we'll have to accept.
Senate Counsel appearing for the petitioner has invited our attention to page 109 of this special. It is part of the petition filed before the High Court, where the petitioner made a specific averment that Messrs. Gulab Sweets is neither engaged in any manufacturing activity of sweets, nor in the storage of ingredients for such manufacturing in the disputed property. Considering such statement, we issue notice, stay. It is made clear that in the event state is successful in persuading us to hold that the petitioner made an incorrect statement before the High Court. It is obvious that the petitioner would be dealt with.
Most obliged, my lords. My lords, the recovery notice may be stayed till then.
State.
Most obliged, my lords.
May please, my lords. My lords, the reference court, my lords, after appreciation of evidence, granted 3,20,000 rupees per acre, my lords. And my lords, this has been now enhanced to, my lords, 6 lakh rupees. My lords will kindly have page 6 for a moment. My lords, the sale exemplar, which has been relied upon by the High Court, is at serial number 1 in the table, my lords. There are 2 tables. Second table. My lords will see. Yes, second table. My lords, this is for only 8 marlas of land, my lords, which is 240 square yards only. And this is, my lords, 10 lakh rupees per acre. Rather, the remaining sale exemplars, my lords, are of less than half the price. And rather, the sale exemplar at serial number 4 is more appropriate, which is of 670 square yards. Which is, my lords, 1 canal and 2 marla, which is for 481. At the best, my lords, this could have been taken care of, my lords. Rest of the sale exemplars, my lords, are all, my lords, less than 50%. And this, my lords, is only for, my lords, 8 marlas, which is, my lords, 240 square yards. And, my lords, the total area acquired is 82,170 square yards.
Don't you talk to your officers? Why should it be decided in a writ petition?
My lords, because...
Why not provide a remedy of appeal before the...
My lords, because this is under the Punjab Act, my lords. Yes, my lords.
That 59.
Yes, my lords.
See that?
Yes.
But 59 says the order of the tribunal shall be final.
Yes, my lords. My lord, landowners.
That means it can only be questioned in a writ petition.
Yes, my lords.
Petition, you are exercising what the appellate court does.
Yes, my lords. My lords, but
Then appeal instead of wait.
yes, my lords. But my lords, therefore I say, my lords, at the best, my lords, exhibit.
Appearing for the Petitioner Improvement Trust has drawn our attention to the particulars of sale deeds produced by the respondent landowners before the High Court to show that the exemplar relating to a piece and parcel of land measuring 8 mallas was taken into consideration. Leaving aside the larger parcel of land measuring 1 canal.
Yes, my lords. 2 Barlat, serial number 4.
1 canal, 2 mallas.
This is the biggest one, my lords.
Recognize the 481, 818. वो वाला 8 mallas, 10 lakh. This will notice stay of operation. You deposit the amount with the court.
Let's stay off the remaining amount in the
Period of fortnight from date, the amount assessed by the High Court shall be kept in deposit with the registry of the stock. Deposited registry to invest. Even the deposit is not, if the event deposit is made, stay shall continue.
My lords, may kindly make it 4 weeks, my lords. This is a
4 weeks.
Yes.
4 weeks. If deposit is not, stay on the standing.
so grateful, my lords.
That's okay, my lord. In execution of a decree of 1989, conveyance was executed by the recovery officer in my favor.
One. Each point is kept open for the DRT to decide.
Let me show
You
that.
appear before the DRT on 4 dates and thereafter you move the High Court challenging the order. You accepted the order of the DRT. DRT asked DRT to decide.
Yes.
You appeared before the DRT on 4 occasions.
Yes.
And thereafter you come before the High Court in a 227.
Just have a look at.
The High Court has said that everything has been left for the DRT.
No, that's the point, my lord. I agree. Just have a look at, I'll tell you, your lordship, which are the paragraphs which are troubling me. Just have a look at page 11 for a minute, my lord. Just have a, no. Let me just make the point, my lord. Then your lordship may, my lord, pass any order. Just have a look at page 11 for a minute. Just have a look at page 11, my lord, for a minute. Just give me 30 seconds.
11.
Yes, my lord. Lord, para 9. I'm aggrieved by para 9, my lord, and para 17. And if your lordship, my lord, give us liberty, that should suffice, my lord. Just have a look at para 11, page 11, para 9. From materials on record, Roman I, title execution was transferred to DRT. Admittedly, point of jurisdiction was not raised. My lord, this is incorrect. Factually incorrect, my lord. It's factually incorrect. I raised it. I can show it from the DRT order. He rejects the point of jurisdiction, my lord, against me. I relied upon Nahar, my lord. And also see para 17, my lord. Just have a look at para 17.
It's come to 11. Even the maintainability has been
No,
left open
that's
for
not different. No, there are two different aspects. Jurisdiction is a separate point. Maintainability is on a different point because the Calcutta High Court order had attained finality. That's not a jurisdictional issue. So this maintainability issue is distinct from the jurisdiction. Now please see page, my lord, para 17 at page 15. My problem is this. Your lordship gives me liberty, I'll be satisfied. Lord, I relied upon Nahar to say no declaratory decree can be granted by DRT. So that's one of the prayers. Lord, they have sought a review of a 1989 Lord, decree after 24 years. And I raised the issue that DRT has no power to decide but all title issue. And I relied upon Nahar and the recent judgment, my lord, in 2025 of this honorable court to say declaratory decree, my lord, cannot be granted by DRT. That is negated. If your lordship sees volume 2 for a minute, my lord. But please see page 297. The DRT or the prayer, my lord, page 297 is the prayer. Sorry, my lord, your lordship is looking at.
We are looking at the DRT order.
Yes.
Which sends it back.
Yes, my lord, DRT order, your lordship will find is page 450.
Yes.
And my lord, the jurisdiction issue.
What is the operative direction of the DRAT? Let us.
Yes, my lord, that would be remand only, my lord. Just see, your lordship will find that at page 474. My amendment is allowed. Their injunction is, my lord, confirmed. And my lord, status is could to be maintained. Parties are directed to appear before DRT. Now, I'm on the issue, my lord. Please see, my lord, para 43 at page 468. How, my lord?
Side RA means RA is review, na?
Review application.
The review application.
Correct. Which was filed after 24 years, my lord.
The DRT has to decide the RA.
Now, true. My lord, if you look.
What has been decided by the DRAT that you are aggrieved?
Yeah, so, my lord, three things were decided, my lord. One, the condonation of delay application, my lord, condoning delay of 24 years, seeking review of the judgment, that, my lord, is granted. Two, my application, my lord, for, my lord, the status quo to protect my possession was declined, but that has been protected by DRAT, no problem, my lord. The other side also has been protected. Now, one of the issues which I raised, two issues I raised. One was maintainability, which is a distinct issue from the jurisdiction issue.
Why did you have to go to the High Court at all?
My lord,
Why did you have to go to the High Court?
Para 43. Para 40. I'm pointing out, my lord. I'm answering. Yes, 43, page 468.
468, yes.
Page 468. No doubt its trite law jurisdiction cannot be conferred by consent. Herein, jurisdiction is not being conferred by consent. A direction was issued by Delhi High Court. No such direction. It's a liberty. That's wrong. There was no direction given by the Delhi High Court, my lord. I can show. It was a liberty given to parties to move the DRT. I can show from the Delhi High Court order. Or the Calcutta High Court for any further orders that parties may require in respect of determining the title or the portion of the property which is contended to be in dispute. This order was not challenged by either party because it only said liberty is granted to the parties. Then, my lord, when parties have accepted jurisdiction of DRT and moved application for adjudication, cannot be permitted, my lord. How can consent confer jurisdiction? And, my lord, para 44 also, my lord, rather a list is to be decided by competent tribunal on the issue when it is to be decided as to whether this portion of the land was a part and parcel of the mortgage property. No doubt, as has been held by Supreme Court in Nahar, DRT cannot decide the title. And I will show prayer page 296, 297.
Last sentence of para 40 and page 469.
469, last sentence.
Parties have accepted the jurisdiction of DRT and moved application
Lord,
for adjudication. Did you move an application?
I moved for protection. Lord, please remember, in execution proceedings, a recovery certificate is issued and, my lord, conveyance is issued in my favor. So I wanted possession, my lord, to be protected. That's why for protection I moved, my lord. But the other side, my lord, 297, if your lordship has Roman 4, 297 Roman 4, their prayer is for declaration or title. How can that be granted? So, my lord, I raised the issue of jurisdiction. The tribunal and the High Court can't say, my lord, that the DRT has jurisdiction. That's my problem. And that's why I wanted, my lord, your lordship to clarify this aspect of the matter. Please see, my lord, my prayer.
Why did you not challenge this order contemporaneously? Why did you have to appear there for 4 occasions and thereafter come back? 227 has to be invoked as early as possible. Why did you do that?
No, my lord, I'm not sure, my lord. Perhaps, my lord, it may have escaped me. I don't know. My lord, I just want, my lord, this clarification to be given. My lord, the jurisdiction issue can be raised by the party, my lord, before the DRT. That's all I'm saying, my lord, today. I don't want to trouble your lordship, my lord.
Lordship, may kindly see page 245 for a minute, what the application is. 245. It starts from, this is the application filed by him. The amendment application, it's way back in 2014, 48G, paragraph 48G. The orders and directions as sought for in this application are extremely necessary to protect the valuable right, title, interest and possession of the applicant over and in respect of the said 2.74 acres of land as mentioned in Annexure X herein details, and the learned tribunal has jurisdiction to pass the same. This is what his application.
No, my prayer 247 is double A.
But this is what his statement is. He himself has stated so.
No, that's what he. I'm asking for protection of the blood conveyances like blood RC. My lord, may I respectfully, your lordship may just say, my lord, all questions are left open for the DRT. That's all, my lord, the clarification I'm seeking.
You are not inclined to interfere
My lord, I'll tell your lordship why.
because of the limited approach to the High Court.
My lord, my lord, your lordship may just consider that's all, my lord.
No. Next one.
May it please, my lords. Dashrath is not on quashing.
46.
Yes, my lord.
Can you
Dash-
include the amount which is already paid in the notice?
So I have 3 checks, my lords. All 3 can't be discounted. My entire complaint can't go. There are 3 checks. One is for 2.13 crores, one is for 2 crores and 2 crores. How does the High Court, my lords, quash all the entire complaint on this ground, my lords, if at all 20 lakhs was paid by cash?
You lodged 3 separate complaints.
No, I lodged one complaint. One.
Veterans.
No, my lords, with respect, it can't. If I have part payment has been made, that's why it's a matter of trial. It can't be quashed.
But it's a admitted fact.
But
that
even
you
if it is
paid the amount which was received by you.
even if it is, I admitted it. He denies it. Please see it. He denies that. Therefore, it's a matter of trial. Please see. I, in all honesty, said 20 lakhs was paid in cash. Now, please see my argument at paid 145. For a moment, please see 145 and see his reply, my lords. He says, no, none of this was done. Now, if he himself denies it and then subsequently files an application for quashing on the ground that payment was made, my lord, it can't lie with respect. It can't. And this Dashrath is plucked. Para of the High Court judgment, my lords.
Yes.
In view of the settled position of this by Dashrath, supra complainant non-applicant against the present applicants is not maintainable in view of the admission of the non-applicant number 1 of having received 20 from the applicant by way of checks. It's not checks, it's cash. Accordingly, the complaint SCC before there, please see my averment in my complaint, I say so at 145. And please see his reply in his reply to my notice. I say at 145, my lords, initially the last 5 lines, my lords, from below, your lordships have the word initially 145 in the first paragraph. Initially, for the month of January and February 19, your notices paid installment 10 lakhs each in presence of your advocate, Chetan Dhore. However, for the reasons best known to your noticee, you have surprisingly stopped paying. Now, please see his reply, my lords, which is over the page. It starts 161. Please see what he says at 161. 161, he says, but for 6.1, there was one notice and he denies it. Please see one.
What he denies or accepts is immaterial.
Yes, my lords.
There could be 3 checks. The amount could be 100.
Yes.
You are issuing one notice.
Yes, my lord.
100.
Yes, my lord.
But in between, he has paid you 25.
Yes, my lord.
Right?
Yes.
You don't make any endorsement.
Yes.
I believe this judgment is by Justice Chandrachu's judgment.
Yes, my lords. That's relating to one check. One check in which payment was made. It does not countenance a situation, my lords, with respect to the question.
Liberty granted in 23, para 23.
No, that is after trial, my lord.
In 23,
In the impugned.
Page 17.
File a suit.
With respect, my lord, this question will arise in every matter, my lords, as far as, please see Dashrath for a moment. Legally, I'm making a submission before your lordship. One, my lord, this is after trial. It has to be led in evidence whether these 10 lakhs was paid, ultimately paid or not paid.
No, has the court clarified that this law will be approved after trial?
No, it is, but it's like in any criminal matter, my lords. If any criminal matter can be quashed after trial, your lordships laid down.
That 100 was due and payable.
Yes.
And you have received 20.
Yes. So this
Can
I
you
make
claim by filing a complaint before the magistrate 100.
Yes. So I'm making a submission, assuming.
How do you distinguish it?
Yes. In Dashrath, it's one check. I'm making a submission, my lords, before your lordships. If at all it has to be there are 3 checks. It can't attach to all the 3 checks, my lords. Kindly see this for the distinction that your lordship. Please see the facts of this case. There was one check. If your lordships has, my lords, page 583.
If you had issued 3 notices, 3 complaints,
Yes.
one.
Yes, my lords.
But you are joining taking 1 notice,
Yeah.
1 complaint.
Yes, my lords.
Why should we take an
Because Dashrath says that endorsement has to be on the check, which is due. Which check? On which, now the question will arise on which check. It can't be, my lords. Now Dashrath is one check.
You could have assumed you could have made an endorsement in 1 check. Your remaining 2 checks would have survived.
Assuming at the
Don't make any.
So assuming highest against me, it can still be only in 2 checks. Milords, kindly consider it can only be 2 checks. Milords, 6.13 crores for a 20 lakh payment in 138, Milords. 6.13 crores, kindly consider, Milords, this will create havoc in 138, Milords. For any endorsement that is to be due, there are multiple.
That is why Liberty has
Milords, just for a moment, I know your lordship.
Either suit,
Milords,
if it is time barred, take advantage of Order 7, Rule 6.
Milords, please countenance the situation. Please allow me for just for a moment, Milords, just allow me. If there is suppose a loan agreement with a particular bank and checks, post-dated checks have been issued and some payment is made in between, the entire working of the financial system will come to a grinding halt as far as 138 is concerned. Every check for an endorsement that 20 lakhs has been paid and this,
the law has to be
Milords,
changed on the
now
interpretation.
legally, since your lordship, Milords, legally 14 and 15 of Negotiable Instruments Act, please consider. Dashrat doesn't consider 14. It has, please see this. Negotiable instrument.
Page 44, SLP to page 44.
SLP page 44.
Yes,
Now, Milords, negotiation is how a promissory bill comes.
you are referring to which section?
14, Milords.
14, negotiation.
So when there is a promissory note, bill of exchange or check is transferred to any person so as to constitute the person the holder thereof, the instrument is said to be negotiated.
Right.
So that is the time when the check is presented. Dashrat says, uses 15. The endorsement part, when the maker or holder of a negotiable instrument signs the same, otherwise than as such maker, for the purpose of negotiation on the back or face thereof, or on a slip of paper annexed thereto, or so signs for the same purpose a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called the endorser. So this endorsement is done when the first time the check is given, that this endorsement has to be there. Now Dashrat uses this 15 with 56, Milords. Now please see 56. Now Dashrat is using 15 for 56.
Negotiation is transfer. For the purpose of.
Just one second, just hold on there.
Right.
So this is negotiation. When the check comes to me from 14, I have negotiated and there comes the endorsement on the check.
If 14 stage is over.
14 is over, Milords.
14 is over.
15 is also over when the check is given.
Yes, when the check is given, 15, when read with 56,
Yes, Milords.
when a part payment is made, you have to make this note.
No, please see now 56 doesn't talk about the endorsement, Milords. 56 doesn't talk.
Next.
55, my apologies, my lord. We are being led by Mr. Devan. He's on his list. May I request for it to be kept on Monday, my lords? My apologies for my lords.
Monday week.
Monday. Oblige, my lords. Kindly pass on.
Your lordships, would you fix up?
57, my lords.
Would your lordships like to take it on an NMD? Your lordships, it may take.
There was an earlier order?
Earlier order, NMD order is there, my lord. Kindly fix it at 2 p.m. It will be a small matter. It can be fixed.
First it will start, thereafter we'll fix.
Next week, my lords. Kindly, my lord, small issue, my lords. Already, my lords have
NMD in May.
May.
He has to find out. He's the master, na?
May, my lords. NMD on May, my lords.
Find out.
Yes, highly obliged.
58.
Lordship, please, lordship.
Huh?
58, my lord.
May रखी. 59.
Lord, in 59, my lord, I'm appearing for respondent number 2, NHAI, my lord. In this matter, we are in a bit of a difficulty. The AOR in this matter, Mr. Chanchal Ganguly, is not contactable. And Ms. Gunjan Sinha Jain has been appearing in this matter as the counsel. She has circulated her wakalatnama to NHAI for signatures. It has not come to us yet.
You want time?
Yes, my lord.
I wish my learned
Second as per letter.
Letter.
I had moved an objection to their letter.
68, yeah.
May it please, my lord, I appear in 68.
My lords,
The issue here is
Dr. Singhvi is on screen if he can be unmuted.
68, there is no letter?
no letter.
There is a letter.
Not in 68. my lord.
In 60, in item 60, there was a letter, my lord, I had objected to it.
Oh, you have objected to the letter?
Yes, my lord.
My lords, I am appearing for respondent number 4. He's muted me.
My lord, we had moved an IA for, my lord, the stay of the, my lord, tender notice that they had moved, my lord, on 23rd of March. My lord, what has happened today is this, that, my lord, they are trying to, my lord, acquire those lands, my lord, which are the lands forming the part of these SLPs. The main issue, as my lords will recall, my lord, on the last date of when.
So why do you want 4 weeks adjournment? Whoever has paid for adjournment?
This is not my case, no?
Who has paid for adjournment? Item 60. Sandeep Devashish Das. He's unmuted, sir.
Well, they don't unmute in time. That's the problem. Well, they don't. And my learned friends don't ask for it. They are there to ask. Well, this is the exact same.
68.
68, well, 5, 6. Your lordship is doing 60?
Yes,
60.
I'm very sorry, well,
That is why they did not mute you. Unmute you. Not mute you. Very well. Item 60, who has paid for adjournment?
Respondent 4.
Respondent 4. Yes, Mr. Kalyan Das. Isko kholo. Yes, Mr. Jana Kalyan Das.
Yes, my lords. I am.
4 weeks adjournment.
My lords, I'll be filing a reply. For that, I have to take instructions and therefore I have sought 4 weeks time. My first appearance.
Then don't auction the land.
Sorry?
Don't proceed for auction.
No, but this is not getting auctioned. The letter says.
Record your submission.
Somebody said it's being auctioned.
We will record your submission.
No. My lords,
Just 1 minute.
we
We
are.
will record your submission that you are not going for any auction.
No, because I am nobody, my lords, the state, my lords. The state is not represented.
Who is for the state of Odisha?
Man, they have not
Well,
entered.
adjournment granted. No auction shall be conducted without the leave of the court.
Very great.
May it please, my lord. 68 involves a very short question, my lord. As to
68, Dr. Singhvi was appearing.
yes, my lord, for the respondent.
For
R2.
For R2. Yes. You are for the
Petition number.
Appellate.
Please.
well, this is the same interim relief your lordships rejected when your lordship issued notice for the reason that there is a statutory bar in 6 acts your lordship knows.
I may place the case,
In
my
the
lord. I'll take only 2 minutes.
IBC Act, in the Justice Rumapal judgment, in the old Act, well as Arbitration Act. It's beyond limitation.
All that
So
is
it's
not
an absolute
disputed.
bar.
My lord, there is an outer limit of 60 days. It is our case that the appeal was filed on the 58th day. Now, the only question is what is the date on which the order was communicated to the public? They say that the date of the EC, on the date of the EC, they've uploaded it on the MOEF website. But
that
our
will be-
case is it was not downloadable. Even 2 months after this alleged
Well,
uploading.
that will be finally heard, but why a
Therefore,
new
the
IML?
undisputed
That will
date
be
on which
finally heard.
it was communicated is the date of newspaper publication, which was 2nd September. If that date is taken, my lord, there's only 58 days within the condonable period. I'm not disputing that there is an outer limit. My case is that it's within 58 days. My lords may kindly see there are multiple co-obligations. There is a 5-member decision of the NGT. It says other than uploading on the website, they should also communicate, put it up on the notice board, communicate to the village
That's the
panchayat.
main matter, man.
And
It's
I
not
have
the interim.
attached an RTI reply by the village panchayat. The village panchayat says they admit in the RTI reply that the EC was never communicated to the village panchayat. The NGT says all the co-obligations must be.
Well, I'm sorry.
Please, my lord, we filed a reply. R1 has filed its reply.
Well, I have my reply ready in hand. I'll file it in 2
The
days.
state
Manoj.
authority. Please, my lords,
Assessment
if my
authority.
lords would just have a look at page, in fact, 251, there is a report from the NIC which we had placed before the NGT, and it's on that basis that this petition was dismissed. It clearly says that it was uploaded on the 28th.
The question is, The statute uses the word communication of the order.
Please, my lords.
How can the NGT read it as uploading of the order?
My lords, that's what it has been. It's not the EC.
We would like to know the basis.
Even the judgments, if my lord,
Communication means communication.
my lords, there can
Why
be
should it be? Why should it be? Otherwise, if you upload, you must at least send a communication to the party affected that look here, we have uploaded.
my lords, he's not the party. He's not the relevant party. He's
We
an
are not-
outsider.
We are not dealing just this case.
Please, my lords.
This sort of orders have been coming up before us quite frequently. So today, if the statute uses the word from the date of communication of the order,
Please, my lords.
right, somebody
Please, my
who
lords.
is not heard by the tribunal or by the law authority,
Please, my lords.
right? Now, if he wants to challenge it,
Please, my lords.
his appeal will always be time barred because he does not know when it has been uploaded. Today, party appeals are not unknown.
My lords, this is like a public interest litigation saying that there is damage being done to the area and he's
He
against
doesn't
the
know.
EC.
He doesn't know. He doesn't know about the proceedings, but orders have
Well, it's
which affects
May I-
his interest.
may
We are
I
not
assist
talking
in
about this
answer?
case.
Please, my lords. My lords is talking about
Yes,
general
Mr.
position.
Person
No,
A,
no, may I assist, Justice?
Dr. Singh,
May I assist Justice Datta's query, my lords? Justice Datta's query directly?
Yes.
There is a specified portal created for this by the government, which is explained from paras 7 to 11, 12,
we are talking of a
where
case,
it's a deemed publication.
we are talking of a case where the appellant before us is not a party before the authority and the authority mistakenly passes an order.
Correct.
Back, and he comes
Correct.
up before us and says,
Yes.
do not know about this uploading business.
So, may I answer that, Bills? I appreciate. May I answer that?
From the date of his knowledge. We need
May I answer that, Bills? I understand.
communication has to be communication.
And one more.
No, your
Your
lordship.
And one
No,
more.
my lords, this is,
All
it's a
kind
government of
environmental violation of all kind of environmental
No, my lords,
laws.
I appreciate. What happens is,
On this technical ground, all matters are being dismissed.
no, my lords, I understand your lordship will go into it properly.
acres, my lord.
I'll just make one sentence, my lords.
Dr. Singhvi, when will you be available? Give us a time and date. We will have to decide this issue once.
No, I appreciate, but I'm not saying your lordship. Your lordship will give me 4 days to file my reply and his rejoinder immediately.
By uploading.
They are constructing in the meantime, my lord. That's
Well, I see your lordship's point. I will satisfy your lordship.
my lord, in the meantime.
I'm going to file my reply in 3 days.
Put it up in someday in 15 May ke baad.
My lord, they are constructing in the meantime, my lord. If they may just
Find that something wrong has been done, we can undo.
grateful, my lord. A fixed date may be given.
Yes, stay take the then.
Following Article 58, I may be permitted to file a rejoinder matter. In 58, my lord, just adjourned it, my lord.
File it.
File it.
So grateful, my lord.
Sama.